Yeah. Well done. Well, good morning everyone. We'll resume the hearing of submissions on the applications lodged by Dunedin City Council for their proposed Smooth Hill Landfill. And just to remind people, if they haven't been tuning in yesterday, that one of our commissioners, Rosday Cleven, is a close family contact of a COVID case, so she will be appearing for the remainder of the hearing on Zoom. Now, just before we proceed, we have a health and safety briefing.
The meeting point is across the road in the car park. Don't re-enter the building until the warden has given the all clear. In the event of an earthquake, please stay in the building, move away from any equipment, windows and furniture, and take shelter under solid furniture if you can. Follow instructions from the wardens. Toilets are located, if you go out the front of the room, turn right, and there's a corridor that will lead you down. Smoking isn't allowed in the venue. You can smoke outside the main doors on the street. And mask protocol, if you could please wear your masks if you're moving around the building at all. If you're sitting down in your seats, you're fine to take your masks off, but please wear as you move around the building. Thank you.
Thank you for that. And just before we hear from our first submitter this morning, anything from the reporting 42A team for us? No? Good. Anything from the applicant for us this morning?
I spoke to Mr. Garrett regarding the timetable that you set out for the quantitative public health risk assessment, and that was all fine.
Excellent. Thank you very much. So what I'll do following the end of proceedings today, I'll just issue a minute setting that time frame out just so everyone's crystal clear on that. So I won't specify precise dates because of course we don't know when the additional report will be received, but I'll set out a minute that will say from the day it's received, here's what happens in terms of those opportunities for the other parties to comment as outlined yesterday, if that's all right.
Perfect.
Good. All right, so the first submitter on our list this morning is Forest and Bird Legal Counsel William Jennings. Mr. Jennings, are you online?
Yes, hello Commissioners.
Yes, good morning. So thank you very much for providing the legal submissions. We've read those, so you don't need to reread those out to us, but you are very welcome to highlight key points and bring any other matters to our attention that you wish to do in terms of the original submission lodged. Over to you.
Thank you. I just had a few words I wanted to read off real quick that I prepared. So yesterday I had an opportunity to listen to some of the submitters. One submitter from the Saddle Hill Community Board said that he had expressed to members of his group that they should trust the system. He expressed to the commissioners his concerns about the system letting his group down. Forest and Bird submits that the system has let his group and others down because this application has been allowed to proceed without the required applications for consents under the Nesfw. The application/activity clearly relates to indigenous vegetation clearance, earthworks, and diversions and discharges to either within 10 meters or within 100 meters of natural wetlands, both within and outside the designation site. The application covers some of these activities through applications for consents under the regional and district planning documents, and others may have been permitted at the time the application was lodged. I'm not quite sure on that. Forest and Bird submits that where rules did exist in the district and regional plans and are covered in the application, that a rule in a district or regional plan may not be less stringent than the relevant provisions in the Nesfw, which are non-complying, and that the provisions of the Nesfw prevail over any application that was not notified prior to the Nesfw's gazettal, which was 5 August 2020. Forest and Bird also notes that the definition of vegetation clearance in the Nesfw is much broader than the definitions of vegetation clearance in both the operative Dunedin plan and the 2GP. The use of this definition rather than the Dunedin city definitions may have also led to the identification of further consents. Where an activity was permitted or not covered by the district or regional plans, further consents may be required under the Nesfw as well, and the council may use section 91 for these further consents. Forest and Bird submits that section 43B's intention and words are clear, Yesterday I had a chance to do a little bit more legal research, and I found one case that was sort of on point on the periphery there. In that case is called Hastings District Council. And in that case, Judge Thompson, after quoting the parts of Section 43B that say rules cannot be more lenient than an NES, and that an NES will prevail over a consent if it is notified after the gazettal of the NES wrote. Clearly then, if resource consent applications had been made after the NES was gazetted, the NES provisions being more stringent would prevail. I submit that the commissioners are faced with a difficult situation here, one that in Forest and Bird submission should have been addressed long before it got to this stage. Forest and Bird submits that the commissioners will need to decide which applications are more lenient than the NESFW, identify other consents that may be required under the NESFW, and then perhaps consider whether those applications could or should be separated from the landfill application. Forest and Bird submits that a robust process going forward would see the whole application, including the NESFW provisions, being processed together. As explained by Ms. Irving the other day, the freshwater package that the NESFW is a part of has indicated a paradigm shift in the way freshwater is managed. Allowing the application to proceed without these essential consents would undermine this shift and run contrary to good resource management planning, integrated management, and some of these consents would be intricately linked with the landfill activity itself and should be processed together. So that just concludes my opening statement, and I'm happy to answer any questions that your commissioners may have.
Yes, thank you very much for that, Mr. Jennings. We'll see if we have some questions for you. Jill, any questions?
I've just got Jan, not Jill.
Yeah.
Good morning. I just wondered, because you heard Ms. Irving's discussion with us on Friday, I just thought you didn't say anything about correcting your own factual position on the notification dates, but they were actually 2021. We all sorted that out on Friday.
I did notice that, and forgive me for that, commissioners.
Yeah.
It was a late night that night.
No, that's okay. It doesn't make any difference to the points you're making because it's the same. They still follow the dates and so on, but I'm just pointing that out to you. I read the Hastings decision, and I don't have any other questions for you really, because I completely understand the submissions you're making, and others have a different view, of course, so we'll just consider it in the realm. Thank you very much.
Thank you.
Ros, any questions?
Good morning, can you hear me?
Yes.
Yes, I can hear you.
Hi, good morning. I did have a question, thank you. On page 4 of your written evidence, you're talking about the effects of the proposal in the event that the consent was considered to be non-compliant. And you've quoted the ORC's Section 42A report in the sense that at the time that was written, the consent officer felt that the proposal was contrary to the key policies. You've obviously been tuning in to some of the submitters' presentations, and I wondered if you had a chance to tune into any of the further evidence that has since been offered from the applicant's witnesses, and whether that changed your view on the effects thresholds in any way?
No, sorry. No, I've been in a hearing the last 2 weeks, so I was able to tune out just briefly.
Oh, okay. That's fine, no problem. Thank you.
Mr. Jennings, I've read your legal submissions, and fair to say I'm not persuaded by your argument, and so I think it's only fair I put to you what my thoughts on the matter are, so you can respond to that. I think it would be unfair if I didn't do that. So my understanding of the process is that the applications were lodged on the 27th of August 2020. The NESF fresh water had not yet commenced. It commenced on the 3rd of September 2020, so at the date of lodgement, consents weren't required under the NES. The applications were amended in May 2021, but the original application was not withdrawn. Merely the scale of the application was amended, which is a very common process. Applicants often amend the scale of their applications in response to submitter concerns or comments from the reporting officers, but the original application stands. Obviously, going forward, should these consents before us be granted, then the City Council would need to seek further consents under the NES Freshwater. Again, it's not uncommon for further consents to be required as part of a major infrastructural project going forward. So in my mind, the only live issue for us to consider is Section 91 and whether or not we should require the NES Freshwater consents to be sought now so we would better understand the nature of the proposal before us. And that's why I asked Mr. Irving what, in her view, information was currently lacking. We have a plethora of information in front of us regarding the effects of the proposal, including effects on wetlands, which would be obviously a factor in any decision we might make under Section 91. You talked about the NESF Freshwater providing a paradigm shift, which of course it did, but regardless of any consents required under the NES Freshwater, we're still required to have regard to the NEMPSFM, which is actually the key document in terms of implementing that paradigm shift. And we've had extensive evidence on that, including from Te Runanga, who provided very helpful and extensive evidence on the application of Te Mana OTY and the sole objective of the MPSFM. So that's where I'm sitting at the moment, and so I think it's only fair I'll give you the opportunity to respond.
Thank you, Commissioner. Yes, I think it comes down, because it's not overly clear in the application, which applications actually relate to the wetlands. I think a lot of the Dunedin City applications that were applied for relate to indigenous vegetation clearance and earthworks that are close to wetlands, or if not on the boundaries of wetlands along McLaren's Gully Road. And in that respect, I think that Section 43B clearly states that the NES provisions would prevail over that, and if the application was granted for that particular activity, then that activity should have been processed as a non-complying activity under Regulation 54. I'm not clear on what other aspects of the application, like for say at the toe of the embankment of the landfill, it's been shifted back so it no longer takes away or makes the wetland at the bottom of the landfill any smaller. But I would imagine there would be some vegetation clearance or earthworks near, or if not, within the limitations of the NESFW there. So and then there are other issues in regards to the regulations as well in terms of discharges that may affect the hydrology of the wetlands. Plus, yes, so that would affect those applications in terms of regional consents. And it's just not clear to me which of those regional consents or district plan consents are actually addressing the activities under the NES. But if they are, then those consents would be subject to the NES FW, and clearly where it says 43B7 prevails. And so in that respect, I think that there's no activity status protection in regards to these applications, because it shouldn't be processed as a discretionary activity. If those activities are in relation to the wetlands, the natural inland wetlands, they should be processed as a non-complying activity, which would change the whole outlook on the way this application process is going, and would have changed a lot of things, I would imagine, along the way.
I think you're missing the point I'm trying to make to you, which is that, as far as I'm aware, and I stand to be corrected by the applicant, is that the applicant has not yet formally applied for consents under the NES Freshwater, and I understand that would need to occur at a later date should the consents before us be granted and should the applicant intend to proceed with construction and operation of the landfill. At that time, whatever the relevant consent categories relating to those NES Freshwater applications, they would apply and be processed accordingly. I guess that's the point I'm trying to make to you, that we don't have to consider which prevails because we don't have those applications before us.
I understand that, Commissioner, but I think that some of the applications that were made, particularly in regards to the indigenous veg clearance rules, do relate to the wetlands, and the application does relate to the NESFW, because that application in Table 9, I think it is, of the application refers to Rule 163424 from the Dunedin Plan, and refers to the clearance of 13.8 square meters of ruatahi, sedge, wīwiri, and other aspects in the McLaren corridor, which I understand from my reading of the application relates to the wetlands there.
All right, well, thank you. Yes, there's no doubt in our minds that we need to consider effects on wetlands, and a number of the consents currently in front of us relate to that. But, all right, no, thank you very much. It was useful to have you comment on what my thoughts are. We'll obviously be giving this further consideration, and no doubt we'll hear from counsel for the Regional Council and counsel for the applicant on this matter. But thank you for your legal submissions and answering our questions.
Thank you.
Thank you.
Now, the next submitter was going to be Munirabura, but I understand, and I'll probably pronounce that incorrectly, but they can't attend, so someone was going to come in and read a statement for them. So, Karen, they're not here yet? No? Okay, so we'll proceed with our next submitter, Lyndon Wiggery.
Morning, Commissioners.
Now, Mr. Wiggery, just for your benefit, because I probably haven't said that yet today, thank you very much for lodging your original submission. You don't need to reread that out to us. But if you've tabled additional information, we're happy for you to take us through that.
Thank you, Commissioner. Yes, I just have four points to amplify for my submission. You'll understand that I'm coming from a holistic, broad perspective of a DCC ratepayer. I'm part of a group that's in the process of reforming a ratepayers association, although I want to point out today that my submission is, of course, based on me as an individual, but you can appreciate where I'm coming from. The first point I want to make is that you'll note from my submission, which was made to the DCC way back in August 2020, I made the point or raised the question why the need to actually relocate from Green Island in the first place. You will know from your own briefing notes that the DCC in 1993 and then subsequent did a great big exercise to identify, in fact they identified 32 sites, and at the conclusion of the investigations, would you believe they came down to just 2 sites. One is Smooth Hill, of course, which is the subject of this application, and the other option was to remain at Green Island. If you look at the costs of relocating from Green Island to Smooth Hill, understand that in the annual plan that's been listed at a conservative estimate of $53 million, and I understand from Councillor Evandervis, who's a good friend of mine, he's a bit worried because of that $53 million, $35 million has been allocated just for the startup costs. So that's getting quite expensive already. It's interesting that I'm not the only one that's actually raising this question, why shift at all, because I understand that previous submitters have actually raised the same question. And in response to that question, the DCC has said this, that option to stay at Green Island has been investigated and discounted during the business case process due to the significant and costly engineering challenges that need to be overcome from a significant expansion of the site. So we don't know what those costs are, and we don't know how to compare those costs of remaining there with the published costs that we already know of $35 million initially, and then rising to $53 million. And as some people in the waste management game have said to me, Lyndon, that's conservative, because if you add all the roading costs and various other indirect costs associated to that, it's going to be a lot more than $53 million. The other thing that the DCC seem to have a real concern about staying at Green Island, as you'll note, is that sewer outfall pipeline that runs through the centre of the tip. Now, my understanding is that that is a problem that is not insurmountable. Technology in waste management is moving at such a fast pace that there are ways and means of actually, I think, from my investigations, of actually going around that. And so I am not one to think that that is a problem that we can't overcome if we decide to stay there. The other point that I want to make is number 2, and that is, if you have a look at the staff report that I have made available to you, and this is a waste management activity report that the DCC have given to the latest infrastructure committee. You'll see it's dated 9 May 2022. And there's some interesting revelations and facts in there. And I just want to point out a couple of them. One is, please note that Green Island is still to be retained. It's still to be retained as what they call a landfill transfer station. And so it's still going to have a life. Also, you will note that there's going to be a new recycling facility designed for Great King Street, because as we know, the DCC have provided for us a 4-bin recycle option, which may or may not commence on the 1st of July. And so it is, to me, very significant that this has been reported to the council at this time. You will also note from that staff report, notice the figures of how the amount of municipal solid waste per person in terms of kilograms is actually going steadily down, which adds to the ratepayer sort of contention that I would like to represent. If we are doing our bit in recycling and the amount of waste, solid waste going into the tip is steadily going down, in terms of our waste, our zero waste minimisation strategy, why are we spending all this money to relocate? I don't believe the DCC have made a very good case. And it seems to me, when you look at this staff report, they are certainly certainly doing very well with the waste going down, and the recycling is something that they are looking at and looking to us to do our bit in the future years to come. So that's another point that I would like to draw to the attention of commissioners. I think that staff report there, which is very relevant, is very timely, is certainly showing, is certainly adding to my contention why shift in the first place. Number 3, the reduction of commercial tonnage to Green Island is something that I would like to talk about. And I raised a question like other submitters have said. What about Nash and Ross? You have on your table there from me a copy of the ODT article where Mick Roche is lamenting why don't we be consulted. I rang him yesterday and I said, were you ever consulted by the DCC? No. Did the Maori people come and consult with you because they have an interest obviously in this whole submission process? No, never been consulted. And here we have this place near Burnside where I take my organic waste. Here we have this amazing place which could take commercial waste. And so I just want to point out to you, commissioners, there is a good question for that offer to be revisited if that's appropriate in terms of this submission. And finally, number 4, I'm confused as to the local Maori desire for the Green Island tip to close. Because on the one hand, that's what the DCC are telling submitters, we have to relocate because the local iwi want us to close it. Yet at the same time, you'll see from the staff report, Green Island is going to remain in some new form as a land transfer situation. So it is very confusing for me and for others as to what their view is. And as I said, it would be very helpful, I would believe, for them to be encouraged to talk about alternative options, including making a trip to go and talk to Mick Ross at Nash and Ross TIP about some alternatives, because they will be concerned as local iwi as any of us about how to dispose of our commercial waste. So that's just my 4 points, Commissioner, that I wanted to amplify in terms of my historic submission. Thank you for listening.
Thank you.
Thank you, Mr. Wiggery. Now, I don't have questions for you, but I do have some comments for you. You've raised the issue of costs. Costs are not a relevant consideration for us. We are charged with considering the effects of the applications lodged and that are before us. The matter of costs relate to the executive functions of the District Council under the Local Government Act, and it's not for us to delve into that. We're well aware of the proposal by the City Council to utilise Green Island for a bulk waste transfer station. We've also been fully informed about their proposals for an organic processing facility and a material recovery facility that you've mentioned. You mentioned or expressed some concerns about the opinions of the iwi, Te Runanga. We've heard directly from representatives of Te Runanga, so we have their evidence before us. So no questions, but just wanted to comment on some of the points you've made.
Commissioner, if I can just offer a comment to your comment. The reason I raised the cost is because that is part of the rationale that the DCC has actually submitted in response to submitters' concerns, fellow submitters' concerns like myself, about why we must relocate. And so I appreciate that you can see from your position that cost may not be a factor, but I think it's significant that in the DCC response to submitters, this is what they are saying, and I have seen that in print twice already as their response to submitters. So they are actually raising significant costs, which I am sort of questioning, but I appreciate that they may not be part of your field at this hearing.
Thank you. I'll see if we have any questions for you. Ros, any questions?
No questions from me this morning. Thank you for your presentation.
And Jan, any questions?
No, I was going to raise a similar point to Rob, so that's nothing further from me. Thank you.
Thank you, Mr. Wiggery. No further questions from me. Thank you for coming in this morning.
Thank you for hearing me.
Now, the next submitter on my list is the Brighton Pony Club. Are the Brighton Pony Club here? Thank you.
Thank you.
So, good morning and welcome to the representatives of the Brighton Pony Club. I see you've taken the trouble to prepare some speaking notes for us. Are you happy just to read them out to us?
Yep.
Yep, and then we'll see if we have any questions for you.
Cool. Thank you.
Thank you.
Hi, my name is Aisha Goswami and I'm a 15-year-old local rider at Brighton Pony Club. I'm also local to Brighton. Brighton Pony Club is a youth-based club in the Brighton Ocean View community. We've had the grounds at the Ocean View Reserve at 812 Brighton Road and have been based there for over 45 years. At the moment, we have a membership of 15 riders, all are under 16 years old. Although we do get members from outside areas, most of our riding members are from the Brighton Ocean View community. During the riding season, we have weekly meetings where children receive coaching on their riding and horse management. Outside of rallies, we exercise our ponies within the community using the Pony Club grounds, roads and streets, and of course the Brighton Beach, which includes the Kaikorai Estuary, the tracks through Beachlands and up to Blackhead. Our young riders love the natural environment and are keen observers of the local wildlife. The DCC Reserves and Beaches Bylaw 2017 officially permits horse riders to ride on most Dunedin beaches and access them by any formed track or designated access point. So since 2017, we have been recognised as users of the Dunedin beaches, and as a pony club, we have encouraged our members to be considerate of the users and other wildlife. With regard to the proposed landfill, Brighton Pony Club wishes to make a submission opposing the landfill at Smooth Hill, and we want to add our support to the wider community's opposition to it. We are a long-standing community-based club, and we do not believe that the landfill is in the best interest of our community or the natural environment surrounding our community. There's nothing better than a sunset ride on our Brighton beach, or even a ride on a stormy day. We love the beach and want to help protect it. Brighton Pony Club is concerned about the impact of the landfill on the water quality of the streams and other water courses and resulting pollution of the beach environment. We would like to point out that the pollution of the Kaikarai estuary by general rubbish and plastic pollution is very evident to us when exercising our ponies. Also, for the past 2 years, we've had the use of a wetland area owned by one of our members, which is located above the Island Park Golf Course and against the Upper Kaikarai estuary. We've had a number of transportable cross-country jumps located there from a Racing Broad grant, and Brighton Pony Club has had a number of working bees where we have built more jumps there. We've had a number of rallies there so we can practice jumping over the cross-country fences. The rubbish that has accumulated along the water courses and the property and along the shoreline of the estuary has been a subject of interest for the members whilst they have been at the working bees. If you look out onto the estuary, it is very evident that there is substantial rubbish that has been allowed to accumulate on the estuary proper. There are numerous tyres, road cones and other such things sticking out of the mud flats and water. We even collected tyres from the estuary to make a tyre jump from them. And the fact that some of the rubbish has been there a long time indicates that there has been little interest in cleaning up the Kaikarai estuary from rubbish that has come down the Kaikarai stream or blown down from the Green Island landfill. We do not want to see what has happened to the Kaikarai estuary occur even closer to home and in our immediate community. Brighton Pony Club has significant concerns about the increased traffic through our community. Given the layout of our community, it is virtually impossible to avoid crossing or riding along Brighton Road. And over the years, the traffic has increased significantly, and in particular, heavy traffic. Road safety is the biggest issue faced by our riders in the community. In order to access the beach from our Pony Club grounds, we use the track along Taylor's Creek. We have to cross the road near the Turning Tides Fish and Chip shop and then immediately negotiate the bridge at Taylor's Creek. This can be quite risky if heavy traffic comes around the corner just as children are crossing the road or are on the bridge. Even a trailer that is making a noise can spook a horse. Whilst we understand that the trucks carrying the actual rubbish will go to the landfill site via State Highway 1, will all traffic to the site use this route? We wonder whether all employees and contractors will be required to use the State Highway route. If not, and it would be very hard to police, then any increase in traffic that occurs because of the establishment of the landfill site will negatively impact on our members and their safety. There is a large number of residents and landowners that own horses in our community. Many people have been attracted to the area because there are suitable properties for grazing horses and because of the beach riding. There are a lot of horse owners that live up Big Stone Road, and now what used to be a quiet back road is going to be a major route for an industrial site. If the landfill went ahead, then it will further change the tone of the community and is likely to be less of an attractive place for horse owners. Many of our members have used the forestry tracks that are available to ride on the Smooth Hill area. These tracks have been a wonderful place to ride as they are safe for young and beginner riders. They are a really nice, relaxing place to ride. Some of our members worried that the Smooth Hill landfill will change the area from a nice place to get away from the city to a busy, noisy and unattractive place for horse riding. The forestry has been felled over recent years and access to the forestry has been restricted because of that. But we really hope that the landfill will not affect our ability to access and enjoy the forestry in the years to come. Also, I just want to say something as a young person living in the Brighton community. The decision on whether to permit this landfill going ahead is going to be decided by people who in all likelihood are not going to be around to see or experience the long-term consequences of it. It is the youth and our children that is most likely to be affected by your decisions, just like the climate change issue. If this landfill fails in any way and seepage occurs onto our waterways, through our community and onto our beaches and its surrounds, our way of life and health is going to be immeasurably damaged. You can't take it back once it's built. That landfill is going to be sitting on the water catchment area of our community forever. And from what I understand about landfills and liners, there can be no guarantees that seepage from the landfill won't occur. In fact, it seems almost every landfill has issues with leaching and liner failure. This is more a matter of when the Otakaya stream will be affected. Even if it's 100 years or 500 years from now, that does not make it okay or the risk acceptable. It's like a ticking time bomb. By building this landfill, you are passing the responsibilities onto your kids, my generation, and then my children. We shouldn't have these pressures put on us. To finish, I'd just like you to look at the last photo. In this photo, there is a quote by the local ecologist Peter Johnson. Back in 1989, in a DSIR report, he noted his concerns about the Kaikarai estuary. This is a quote from that report. Kaikarai estuary, perhaps because it's still crudely used as a site for 2 rubbish tips in its upper catchments, tends to be treated with unfortunate disdain despite its ecological role and significant botanical wildlife values. Fast forward to present day, some 33 years later, and the rubbish is still present at the Kaikarai estuary. How can this be? How can we have any confidence that the proposed landfill will be any better? Is Otakais Creek and its associated marshland and ultimately Brighton Beach going to be degraded and used like the Kaikarai estuary? I really hope not. Thank you for giving me the opportunity to speak on behalf of the Brighton Pony Club.
Thank you very much. And do you wish to say anything in addition?
No, not really. I am the president of Brighton Pony Club, and yes, the traffic safety issue and the concerns that we have for Brighton Beach. The children do love the beach. It's one of the things that make us unique as a pony club, really. That we've got that right beside us, and it's used extensively by everyone in the Brighton community and wider community. A lot of people will transport their horses to come and ride on the beach. So there's a lot of people with, vested interest in seeing it, be retained as the beautiful, wild, natural beach that it is.
All right, thank you very much. We'll see if we have any questions for you. Roz, do you have any questions for the Brighton Pony Club?
Yes, I do. Can you see me? Hear me?
We can hear you, can't see
We can
you
hear
yet.
you.
Oh, that's okay.
Now we can.
Hey, thank you very much for your really strong submission. I didn't catch your name at the start.
Aisha Goswami.
Aisha, thank you so much, Aisha. I really enjoyed your presentation. So you've got about 15 riders in your group, is that right?
Yeah.
We have 15 riding members, but we have obviously all the parents and coaches and other members associated with that. But yeah, 15.
Right. And what's the age range of the riders?
Our youngest has not long started school. I think she's either 5 or 6, up to Aisha,
15.
who's 15, and we've got 2 other 15-year-old riders.
Right, and so when you're out doing your riding activities, you do it as a group generally, is it at the weekends or during the weekdays?
We have a rally on Wednesday nights, so we come together as a pony club. Obviously there's friendships formed within the pony club, and we often will ride together, exercising our ponies. We do sometimes, for a rally, go for a beach ride. We do use the beach. We're very close to the beach. It's just basically on the other side of the road, Brighton Road, and there's the sand, there's the houses and the dunes, and then there's the beach sort of thing. So, yeah, very close proximity.
Okay, thank you. And yes, once again, thank you for your presentation today.
Thank you.
Jan, any questions?
I've just got a couple of questions for you, Aisha. Well done, because that's quite a big step for you to take today, to come along and present the way that you did, and you did it very well. Did you write it as well?
Yeah, me and my mum worked together to write
You
it.
did a really good job. I've just got a couple of questions about the Pony Club and particularly around the forestry and the trucks. So we've been up to the site and we had a drive around up there and a walk around, and so we know pretty much where all of the forestry areas are. Do you ever encounter logging trucks up there on your ponies?
Yes, we do, and it can be quite we have to get off, and because the horses do spook at big trucks when they go past.
Yeah. And do they come at you quite quickly?
Yeah, they can do.
Right.
sometimes we don't have much warning. We have to try and get off the road. The heavy traffic is a definite concern, and especially through the township.
One of the things the applicant has put forward that you probably have seen in the documents is that the trucks will be going along State Highway 1, and we have been giving some thought to how, if we were to grant consent, how you could condition that, because you can't put conditions on third parties to require them to do that. But we are still working our way through that process in terms of the legality of things. What about when you take your ponies up to the forest to ride? Where do you tend to access to do that?
Well, there's not many good parking spots, so we tend to try and just get off the road beside the big forestry gates. Is usually a bit of a pull-in.
Yeah, and you just take them up there and go into the forest.
But it's not great access.
No. Okay.
We have to be confident in our ponies, and because we're tying up the ponies really close to the road too. So if heavy traffic or any traffic goes past, depending on the speed they're going, it is a bit of a concern. But it's such a lovely place to ride. Especially when my children were younger, we went up there a lot. And it's just a really nice place to get away too from the city. And we really feel fortunate that we have had access to those forestry tracks. And we hope that it's going to be something that can be something we can do in the future too.
You talked before about the trucks coming through the Brighton Township. So these are the logging trucks or just a variety of trucks?
Just in general, the area is just more and more busy. The logging trucks are a real concern because they are such a big vehicle, and they often are going quite fast. But just in general, we've been living in Brighton for 10 years, it's just become busier and busier, and every time, in order for the children to ride in the community and go across the road and to the beach, we can't really avoid the roads, and it is quite a concern. There's laws, there's obviously speed limits and conduct that people should abide by, but there's a lot of people that don't. So the fact that, even as you say, you're not sure about it's more the third party increases in traffic that we are concerned about, because just concerned that it's just going to make the road more busy.
Okay, well, it's certainly from the impression we've all got, I think, is that Brighton's grown an awful lot in the last few years and changed itself from a town of cribs to more of a permanent resident population, so that's probably got some impact on it. Otherwise, I understand completely your points, so thank you very much for coming in, both of you.
Thank you.
No, don't go yet. So, just like to comment, one comment and then a question for you. So the first comment is in regard to the issue of traffic, which a number of submitters have drawn to our attention, concerns about the potential for heavy vehicles, rubbish trucks, accessing the proposed landfill to traverse through Brighton. And as you've heard this morning, and you probably already knew, the applicant, the Dunedin City Council, intends for those trucks to go along State Highway 1 and then up McLaren Gully Road. And people have said, well, how do you make them do that? I mean, I've done a number of consent hearings around the country for similar operations, including major quarries where similar issues have arisen, and we can impose conditions on consents if they're granted, requiring particular vehicle access routes to be used. We can also impose conditions requiring the consent holder to obligate their contractors to use those same routes, and these days a lot of the heavy vehicles are fitted with GPS trackers, so it's easy for the council to identify if someone's not going where they should be going. They're just some of the issues that I've been dealing with on other applications around New Zealand in terms of this issue. So obviously we've yet to hear from our reporting officers and the applicant in reply on that matter, but it's not an intractable problem. Just in terms of the Otokea Creek, the Pony Club activities involve the beach at and around the mouth of that creek?
No,
Okay.
not permitted to have horses on that beach.
Okay.
we have occasionally at other spots in the Otakai Creek, access the creek, but not formally or not, it's just on a ride and with the permission of private landowners.
Yeah. Okay. All right, thanks very much. No further questions for me, but again, thanks for coming in this morning.
Thank you.
The next submitter on my list is Generation Zero. Morning.
Tēnā koutou katoa. We are Eva and Jet from Generation Zero, which is a rangatahi-led climate justice organisation. We mobilise New Zealanders to support and campaign for intergenerational climate justice. As the student-led Dunedin branch of Generation Zero, we are particularly concerned with the environmental issues that will continue to affect our generation in future years. Smooth Hill is unfortunately such an example of a short-term solution that will only cause more damage for future generations. We must focus on viable long-term solutions to protect our environments. This proposed action could jeopardise the future livelihood and health of Otago residents. We can't stand by and allow this to happen. We are here today because we do not support this application, which we believe will result in numerous negative impacts on the surrounding environment and community. Simply put, the effects of this application are well more than minor. There are no justifiable circumstances under the RMA which this application should be approved. Firstly, the application does not reflect long-term environmental planning and waste minimisation goals outlined in the DCC and ORC 10-year plans. We, Generation Zero, gave a submission regarding both plans last year and were impressed by the level of transparency and commitment to sustainable development shown by both councils. The ORC's commitments towards freshwater and wildlife were particularly impressive. Specific ORC plans, including improving water quality and restoring biodiversity in waterways. The proposed landfill clearly goes against this, with multiple major potential impacts on these environments. The negative impact that the landfill will have on the black-backed gull is a clear example of this. Lethal control measures proposed are of particular concern as well. Smooth Hill flies in the face of this commitment and jeopardises the ability of the ORC and DCC to reach their environmental goals. The application is blatantly unsustainable and is distracting from a greater issue of inadequate waste management and culture in the Otago region. Smooth Hill only provides a short-term solution to waste. It is not an efficient or well-thought-out proposal to safeguard our futures in a time of climate crisis.
Furthermore, we'd like to talk about the potential negative impacts of the dump on the wider Brighton community. The Class 4 landfill that's been proposed includes many dangerous substances, including asbestos, which could potentially have serious effects on the surrounding community. We know environment is defined in the RMA as encompassing both physical and human environmental impacts, and the Smooth Hill landfill has potential to cause severe impacts to both of these environments. The community has been really vocal in expressing their discontent with this plan, citing the many potential impacts on their welfare. We've just heard from Isla, who's given a really powerful speech as to the impacts on the Pony Club. And you've seen many other community members in the last few days of hearings. They wouldn't be here if they believed the DCC was managing this consent application genuinely and well. We need only look at the time frame of the resource consent application that Forest and Bird spoke to this morning. 5 days later, and it wouldn't have gone through. We heard Andrew Rumsby on Friday and his submission on the risks of bioaccumulative substances. That highlighted just one of the many risks that this landfill poses to the health of Brighton residents. We also know risk is a combination of both chance and consequence, and while the chance of the landfill liner rupturing may be low, the consequence is extremely high. There are really valid concerns surrounding potential odour, risk of fire, increased pests and decrease in property values in the area in close proximity. And also mentioned have been the impacts on members of the community with underlying health conditions, with an incident potentially having really disproportionate effects on those people. The ORC has a responsibility to listen to the general population of the region, especially the vulnerable population of residents in Brighton, who will suffer the effects of this landfill. The community has spoken, and we only ask you to listen. Put into summary, the application fails to meet a number of grounds under the RMA that the ORC must consider. The human environmental impacts are significant, and the impacts of the landfill do not fit with the ORC's long-term environmental planning and waste management goals set out in the 10-year plan that we spoke to last year. The environmental effects are well more than minor and will cause harm to the Brighton community. As such, we can't support such an application. Thank you very much for listening. Tēnā koutou.
Thank you for that. I'll see if we have any questions for you. Jan, any questions?
I don't really have a question quite, but I just wanted to ask you, I take it, given your focus, that you have some, just trying to think of the right words, the waste minimisation goals of the council that it says it's trying to achieve have some level of positivity, I'm assuming, for you, because they're trying to separate out wastes and reduce them. So you're okay with that part of it, I assume. It's just your argument is then that you don't think the landfill should proceed at all, or there should be no landfill. Where are you at on that front?
We spoke to the 10-year plan last year, and we're strong supporters of the ORC's commitments to minimising waste as well as the DCC's. At the end of the day, this landfill presents what we see as undue risk to a community. The location was designated, first identified in the 90s. A lot has changed since then. And I think it is extremely telling that so many community members have spoken out about this. We're not here today to come up with the solution for where a landfill should be, what that looks like, but we have very genuine, large concerns about placing a new landfill, a class category 1 landfill, in a vulnerable coastal location.
So the question I was trying to ask you, I'll try it again, was not quite so clear perhaps. In your own organisation's philosophy, if you like, do you accept that a landfill should take waste at some location if there is waste to be deposited that can't go somewhere else? Or is that, I've come across various people involved in zero waste initiatives throughout New Zealand, and some say yes and some say no. So what's your position?
I think in the short term, yes. In the short term, there is a need. We can't switch off waste streams overnight. But this isn't looking at the short term, this is looking at a very long term. And in that case, we can't support it.
Okay, that was all I had. Thank you very much.
Thank you.
Ros, any questions?
Yes, I do have one question. In your written evidence, you raise a concern around the landfill potential to attract birds, most particularly the endangered black-backed gull. In recent days, we've heard from experts in avifauna, and they've clarified that the black-backed gull, it's not endangered, and I wondered whether that changes your view in terms of lethal concerns around lethal weapons, lethal shooting, lethal methods.
Really valid question, glad you asked. At the end of the day, whether it's endangered or not doesn't change our perspective. There is a lot of wildlife in New Zealand that may or may not be endangered, but we still don't support the culling of them due to a landfill.
Okay, so your view is that no lethal methods should be used. I think, that's clarified that point for me. And the other question I had from you was similar to Jan's question around any research that you may have done on other landfills around the country that may have informed your submission. But I think you've probably answered that one.
Yeah. Any further point to clarify on other landfills around the country is the fact that landfire, I think I particularly talked to the liner of the landfill. This we live in an earthquake-prone country. A number of submitters have brought up risks of the landfill liner rupturing in any way, shape or form, and we believe that no matter the genuine best efforts of the DCC and other organisations involved in designing the landfill, there is still an unacceptably high risk of rupture of a liner, leading to waste leachates. You look at the West Coast and the flooding in the past few years, unacceptable risks.
Okay, thank you very much.
Thank you.
Thanks for the presentation.
And no further questions from me, but thanks very much for coming in this morning. Appreciate it.
Thank you, Commissioners.
Thank you.
Now, do we have any other submitters who have indicated a wish to be heard and have not yet been heard? No? Well, that brings us to the conclusion of this part of the hearing, and we're now adjourned until 11 a.m. Is that still your target time, or has that changed?
That's still the target time for getting you the report and the legal submissions. We can send that. We can come back to give it to you, or we can send it by email. Or
Yep.
Send it
Okay.
by
email.
So I think we don't need to and Kirsten, yours as well.
I've just sent mine through to Karen to circulate to you.
Excellent, thank you very much. So just for people watching, what we're discussing now is the feedback that's going to be provided to us by the reporting officers from the Dunedin City Council's regulatory arm and the Otago Regional Council. We'll receive those documents. I don't think we need to reconvene to receive them. We can just receive them. And then at this stage, we're scheduled to reconvene at 2:30 to pose any questions we have to the reporting team.
Mr. Randall's on his way. He'll be here about 1:15.
Mr. Who?
Randall, the gentleman who's speaking for the submitter who wasn't able to get here.
So they're just going to read something out?
Yeah. He's got a PowerPoint presentation as well.
There's one submitter who can't appear and has asked for someone to read their submission out to us. We've stressed to them through our hearings administrator that there's no real point in doing that because we can't ask questions of someone who didn't write that evidence, but nevertheless, should that person arrive, we'll then reconvene to hear what they wish to say to us so that we don't exclude anyone. So we'll adjourn for now and reconvene when this person who arrives, who's going to read out someone's statement to us. And I'm not sure when that will be, sometime around 10:15 perhaps. Okay, thank you. Good morning. We'll reconvene the hearing of submissions on Dunedin City Council's applications regarding the Smooth Hill landfill. And at this stage, we're hearing from a person appearing on behalf of an actual submitter, Munura Bura. So Mr. Randall, can you come up, please?
Here is it?
Yes.
Thank you.
Just before I turn to you, though, Ms. Lindsay, just in terms of your end of hearing report, the commissioners have read that. We thank you for it and its comprehensive nature. We have no questions arising. So at the conclusion of the presentation from this person speaking on behalf of an actual submitter, if there's nothing you wish to add as a result of that, you're free to go.
Thank you.
Thank you for your assistance throughout the process. We appreciate it.
Firstly, my apologies for keeping you going. I've been through these processes before. I understand fully you've had Manira's submission. It's okay to have my mask on.
Yeah, Mr. Randall, just take a seat and
Okay.
then I'll have some comments for you. So yes, we've received Mr. Bura's submission, which we've read. I understand he may have prepared a written...
Sorry, it's a she, Manira.
She, okay, thank you for that.
It's okay. It's an unusual name too.
Yeah. All right, appreciate. She may have prepared some speaking notes which she wishes you to read out loud to us. We've tried to explain to you through our hearings administrator that it would be sufficient for us to read that ourselves because we cannot ask you any questions arising because it's not your evidence. Nevertheless, you wish to read it out loud to us, so that's the opportunity we're now providing to you. Just two caveats on that. As set out in our procedural minute, we don't require you to read out any information that's already been pre-circulated because we've read all of that. So you're not to read out any text that was in the original submission from Ms. Bura, and we'd appreciate it also if you didn't read out any text where it's just a direct quote from someone else's evidence or another report that we've already read. And you're not to express any of your own opinions as part of this presentation to us. Your sole role here is to read out text prepared by Ms. Bura.
Read out. Sorry, you mean that she didn't know about this, so what she asked me to do was to expand on her submission for her. And so the part that I was going to expand on for her was her concerns about the effects of wildlife, I followed the whole hearings. I'm aware how they work. I was part of the NZJ's hearing down here, which was the last big hearing. And so my understanding was that on her behalf I could expand on some points she wanted to expand on, but what you're saying is that only stuff that she's prepared.
Correct.
Oh, well, she hasn't had time to do that. She was confused by the whole process. She just asked me to go into the wildlife in terms of my expert. She's a friend of mine, but she just hadn't realised the situation. She'd been away on the weekend, hadn't realised she had some time to speak, asked if I could do that, that's all.
Yeah, just a minute. I'm just going to confer with my colleague. Right, so we're prepared in this case to accept that Ms. Bura has asked you to appear as a witness on her behalf. So you may make your presentation to us, but just repeat, please don't read out anything that we've already read by way of pre-circulated material, including original submissions, evidence or reports that we've already read.
I absolutely understand the process. I have been through these processes before.
Right.
I do understand the RMA and the current framework. And I just have to say that I'm sorry, but I've had to, it's been a last minute thing for me. I appreciate that you've made the time for me to it's important, I think, that people have their say. A lot of people have submitted under this process, and I'm sure in terms of other hearing processes you've been involved with, it's a large number of people, and then the people who get to speak are the people who actually get to bring those things to the table. So it's unfortunate that Manira couldn't be here. Her circumstances have changed with her job, so she's asked me to do it. Yes, I can be an expert witness for Manira because I'm qualified in terms of what I'm talking about. but I'm an independent witness. I don't work for anybody, if you know what I mean. I'm an independent ecologist. So that's okay?
Yeah, as long as you adhere to my request not to read out anything that we've already read.
Absolutely. Can I state my qualifications and experience?
Well, we do have your written notes. We've read.
Oh, okay.
We've read those qualifications and experience.
Right.
So maybe if you find an appropriate place to commence reading.
Okay,
other
sure.
than that.
So I can refer to. It is appropriate to refer to documents that you have read, but not read parts of them out.
Yeah.
What I've done is I've just, because it's been hurried, I've cut, copied and pasted stuff.
Yep.
Is there a copy for me with my bits that are highlighted? Because I sent it through to because all I've done, I'm not going to, what I've done is I've cut, copied and pasted stuff I'm going to refer to. I've just highlighted some points, and that's what I'm going to refer to, not the whole lot.
Yeah. And my colleagues just reminded me to remind you that on the basis that we'll receive your evidence as an informed layperson, we won't consider your evidence as expert evidence. Expert evidence was required to be pre-circulated well before this point in time, and there's a normal standard of evidence from experts, including where they agreed to abide by the Environment Court Code of Conduct for expert witnesses. So we'll receive your evidence on behalf of Ms. Burra as an informed layperson.
Okay, that's fine.
Yep.
All right, but I've just made brief notes about what my history is, and I have worked as an ecologist before and as an ecological advisor, but I'm not here in that capacity.
Yep.
So, just sorry, because all I've got in front of me is notes which don't have the bits highlighted. Obviously, I'm not going to go through all of this. I just want to go to the bits that I've highlighted. Mm-hmm. Is it possible? Was it possible to have one of those, Karen? Okay, thank you very much. So, just with regards, I've just copied the bits of menus that she wanted me to follow through on. I have followed the hearings. I think I'd just like to comment that I think I've been really impressed with the hearings. I think it's been you've been very accommodating with people, and I appreciate that I was running late, but it was a last minute thing for me, and I just think it's been a very well run hearing process, and I've been the fact that everyone's taken everything on board. You guys have you've done a very good job, everybody, is what I think. So in terms of my specialist area, that's Onycophora, which is the relevance of that is in terms of wildlife, in terms of the Boffin-Miskell report. And I see that this was mentioned by Lisa Bossart the other day about, in terms of that report, I can refer to that report, yes? Is that okay, the Boffin-Miskell report?
You're welcome to refer to reports. We just don't want you to read out anything to us that we've already read.
No, exactly. You've read the reports, that's right, I understand that. So it's in terms of what's missing from that, in terms of the fact that it's very incomplete, and obviously it's very hard for everybody to make an assessment in the face of incomplete evidence or incomplete information. For example, one of the important things is that there's been no invertebrate survey of the area whatsoever. Onycophora, for example, and I do note that Lisa Bossard mentioned about some of the smaller things, spiders and things that aren't considered in invertebrates. Invertebrate fauna, whereas New Zealand has a really precious invertebrate fauna, they tend to fall between the cracks a bit. In terms of Onycophora, there are Onycophora, by the way, are perivitus. That's a picture of one up there. This is my specialist area. Are almost certainly out there because they're everywhere, and they thrive in those areas of disturbance, not in primary forest. So, and they are something that's seen as an iconic species for Dunedin because they feature in all the literature, they feature in the books, the promotional videos and everything around there. There's actually a picture of one out at the airport when you come in. That's because of my efforts to raise the awareness of them. There are disappearing fauna. They're disappearing from many areas in the rest of the world. Dunedin is one of only 3 cities in the entire world where you can still find them in urban locations. There's an entire scientific community dedicated to the conservation and preservation of these animals, and they're seen as, well, they call them an iconic part of our wildlife. I'm currently doing a taxonomic review of the entire fauna, which is really hard because they don't get protected unless they've got names. Until things are scientifically named, they fall between the cracks. So the Department of Conservation, for example, will not do anything about them, but they would if they had a name. And the same thing applies in other countries. I mean, the fact that they're there is amazing because they're getting lost in Brazil by comparison faster than they can be described. But the ones here, we now know from genetic study that's being done, is that there's probably like 200 species of them, and so we have a really diverse fauna in terms, which is, if that's true, which is what all the overseas experts reckon, then that would be almost half the recorded Onychophora fauna in the world. There's certainly others to be named, but Dunedin being only, it's a really important part of Dunedin in terms of our wildlife values. The animals out there, given that when I say out there, there hasn't been a survey. I'm not saying they certainly are there, except they're finding them everywhere now. The roads, for example, where NZTA does any roading projects, because I wrote a management plan for them, they now look for them everywhere and they're finding them where they didn't think they'd find them before. As long as there's been continuous habitat, which is continuous vegetated area, they're almost certainly there. And it's that disturbed area that they thrive in, as do so many other animals. And I know this is something that Lisa Bossart made. Actually, I know her from before, but I have never met her. But and as she said, she's not an ecologist, but she does realise that the important thing in looks of animals, in terms of looking after animals, especially vertebrates in this situation, is looking after ecosystems. And that's part of the Resource Management Act. It's the intrinsic value of ecosystems. But in New Zealand, we tend to have people work in their silos, and we have single species management plans, which are dangerous, and they've been there. I know this is what the framework that you work within, but it is actually this is directly related to Smooth Hill and directly related to quite a few of the submissions. Thank you very much. That's great. It's directly related to what's happening at Smooth Hill because it's directly related to proper management, and it's relevant to what's in the Resource Management Act. I've basically highlighted the relevant points from the Resource Management Act in my notes. I don't need to, you guys, sorry, the commissioners and everyone else is well aware of what the Resource Management Act says. I do not need to say that. I've highlighted the relevant bits. So in this instance, for example, in terms of mitigation that's being applied for, we have 2 single species management plans which are being talked about, a falcon plan and a lizard plan. Now, that does not address the intrinsic value of the ecosystem. Now, the ecosystem is not defined by native plants. My management plan, for example, which is not relevant for there, but is now used all over the place, stresses that these animals are found wherever they're found. They will live where they want to live. It's adaptive management. Adaptive management is actually a tool of ecology. You adapt when things aren't working well. But adaptive management, that's what native species are really good at. They'll adapt to any environment. It might not look like much, but the prime habitat for an Onychophora at my place, where I've got good numbers, is a pile of bricks or a plastic bag. Yet everything's judged in in native vegetation, which actually in the Boffin-Miskell report, for example, it says pine plantation of low ecological value. Onychophyra much prefer pine plantations to primary native forests. In Australia, they've done longitudinal studies which show that they're more prevalent in those areas, and then they become more. I'm using them as an example of animals which thrive on managed disturbance or accidental disturbance. So wildlife is much more prevalent in the disturbed areas where, for example, there's the cycling of material and invertebrate food source becomes available, as opposed to primary forest, and that's well known. It's called there's a name for it under ecology. So in terms of the report that's been presented, it's, I've analysed all the reports. I've seen I've read the Boffin-Miskell report. I have read many such reports in my time. That is, let me put it, one of the most incomplete ones and that I've read, and it is flawed in many ways, and there are lots of unknowns. There's a whole section about uncertainties and unknowns in it, which is probably not a really good look for a report. But I do realise that because of the whole thing being put through at such a stage, they acknowledge it needs more work and nothing's been done. But it's very hard for people to make an assessment of the impacts of anything without a proper ecological assessment and a proper and full assessment of environmental effects, which is what's required under the Resource Management Act. So to me, obviously you've seen the report. It's very hard to read, and it's stuff being crossed out and added in bits and pieces. It doesn't read well. So even for your average lay person who wants to try and read through it, it's a very, very hard report to follow. I refer to the Tonkin and Taylor report, which points out some concerns. But obviously I know how these things work. These various people, they're professionals, so there's only a limited amount that people can criticise or point out because they're part of a professional group. They work with each other at various times, ecologists, and they work against each other at other times. That's the way it goes. I don't, because I don't do that, so I'm free to comment, I believe, on behalf of the submitters, especially the submitters who do not understand the ecological principles.
Just to clarify, Mr. Randall, you're speaking on behalf of one submitter.
Okay, fine. Thank you. The threads that came through, which Manera has noted, in which so I cannot refer to the threads which come through in her submission.
You're here today to speak to us on behalf of the submission.
Okay, so her
Burrow.
submission, okay,
Yep.
as she said, and I did talk to her about this before, but this is before I knew I would be doing this for her, when she asked about the ecology and whatever, is hard to understand the assessment because it wasn't written in a form that she could understand and that many people could understand, and it was hard to read. So I think that makes it hard for the layperson. And then, of course, unless people call in an expert witness, then it's very hard for them to assess the information that's been provided. So that would be a comment from Manera that she made to me. But as I said, that was made before I knew I was going to come and have to do this. That was some time ago. So in terms of fauna, things fall between the cracks. Obviously, the Onychophyra, which I believe would be out there, and every Onychophyra. I work with Onychophyra specialists, for example, all over the world. As you say, I'm talking about her. She mentions wildlife in general that she's concerned about. So I can point out this part which has been dropped out, or she does specifically mention the lizards and the concerns about the lizards and the falcons. So I've made notes about those, which I understand you guys, the commissioners have. So I don't need to, as I said, they're bullet pointed, they're from documents, I've highlighted relevant pieces, so I don't need to go on any more about that.
Yep.
So in terms of a proper environmental assessment that people can look at with any degree of certainty in terms of whether there can be mitigation or not, then you actually need a full and proper assessment, and otherwise a basic ecological principle is absence of evidence doesn't mean evidence of absence. So in terms of the onychophora, which I believe, in my experience, because I would be, and this is something that Manira knows about, she knows that I do this work with onychophora, so she's fascinated, but she's certainly not a specialist. So if I can expand on that aspect of it, given what we now know about the genetic and morphological biodiversity, and I am working with people on a multinational project now, people in Brazil, Spain, whatever, that I do not claim to be a taxonomist. I'm a conservationist and a wildlife manager. But I believe these people, the top people, that any animals out there would almost certainly be a different species to anything that's been described. So without knowing that and without doing the taxonomic work on them, it's very hard to know how to make a decision. I mean, how can you mitigate for a loss of something until you know what it is? Or how can you propose mitigation? It's actually the same with the grass skinks. For example, I know the lizards mentioned by Manira. It's now believed that isolated populations of grass skinks, which are isolated from the meta population, which is the wider population, almost certainly will have some genetic variation. Whether they have speciated yet or not is not sure, but to lump them all in as grass skinks, it's now recognised there's at least 7 different clades, that's family groups which are totally separate. Without that work on those ones, you can't say they're the same as every other grass skink. They cannot actually, given their limited range, they cannot interbreed, they cannot move between populations. They are an isolated population by geographical reasons and other reasons, the likes of rivers and things like that they cannot cross borders to them. And in terms of the falcons, and Maniras, this is a lot of people have shown concern for the falcons. They've mentioned them, but in terms of, and I noticed in Manira's submission, as many other people have mentioned, they mentioned concern about the bird strike issue, which obviously is very concerning, both from a human aspect and from the impacts on avifauna. Now, and let's see that Mr. Markham notes that, as I said, I've read the reports, that any bird strike should not just be limited to the black-backed gulls, it's any bird of 50 grams or otherwise as a guide. So that would pretty much include anything out there that flies, apart from your really small birds, and even in a flock. Small birds have been known to bring down planes. It's a fact, that's happened overseas. It's just even small flocks, just by numbers. It's not just to do with weight if they get in the wrong place. So this is something else that Manira's mentioned, and as I said, in terms of that, how do you manage falcons, for example, in terms of bird strike? If they're living in that area. And another concern, as I realise now that I stick to Manira's, in terms of animal welfare, in terms of contaminants and everything like that, is an area that I know about. And in terms of any pest control at the dump, you will have already seen the bits and pieces I've highlighted. I do not need to basically expand on those. You've got the notes. I work with people. I am experienced enough in terms of the people I work with to qualify on the use of second-generation anticoagulant rodenticides, which is what's the most common poison, common toxin that would be used to control rodents. Almost certainly, it says, I think without a doubt you would find that any landfill is going to attract rodents. And trapping by itself will not work. You need a variety of measures. I see the variety of measures that have been proposed, even as far as screening it and so whatever, but they will end up there. And anticoagulant rodenticides, basically they take a long time for the animals to die. I mean, there's a welfare issue in terms of animal suffering, because people are mentioning wildlife, they're not just talking about endemic wildlife or native wildlife. And secondary poisoning is a huge issue with those animals. Any animal, any carnivorous animal, I mean, for example, your moorpork, your falcon, harrier, obviously very, very prone to them. Although they're a native bird, they are self-introduced as opposed to endemic, which is what, there is a difference, and that's not noted, obviously, in the Boffimiscal report, the difference between endemic, tui, for example, are endemic, and yet harrier, and they're not actually a hawk, by the way, even though they say harrier hawk, they're an actual harrier, and they're called the Australasian harrier, which are ubiquitous around the Pacific, but they exist here and they arrived here naturally. All of those birds are susceptible to second generation poisoning, which means, for example, I mean, I can provide science to back all this up, but this is a particular area of study. It takes 2 rats in a trial, which two sublethally poisoned rats in a trial to kill a barn owl. Now, they're the largest owl in Europe. They're huge. So it doesn't take too many mice to kill a moorpork or any other bird of prey that we've got here. And also, whereas lizards themselves and invertebrates are not susceptible to the poison, they carry it, and it's the animals that are susceptible that die from second generation poisoning. You can even get 3rd generation poisoning. And it's the bad thing about any of these anticoagulant poisons, which are used for, the good thing about them, as far as the pest control people go, is they're cheap, they're easy to disperse, and they are effective in the long term, but they bioaccumulate through the food chain, and they persist. From memory, as I said, these are just notes, from memory, Brodifacoum persists for up to 4 years in the environment, and it bioaccumulates.
Yep.
People go on about...
Mr. Randall, I might just interject here. We've been listening to you carefully now for around 25 minutes after we adjourned for 45 minutes to await your attendance.
I was sorry about that.
Just a minute, I'm still talking. We understand the gist of your presentation to us this morning. You're concerned about the ecological assessment relating to velvet worms, lizards, falcons. You're concerned about bird strike and pest control techniques. Do you have any concluding comments that you wish to make before we see if we have questions for you?
Can I can leave it at that. You have my notes, okay?
Yes, correct.
Thank you very much. Can I just, a very quick PowerPoint on Ecofra, if anyone's interested, or I brought it along. If you don't want to see it, that's fine.
We can, if you can leave a copy of that.
I can leave a copy of it.
We'll have a look at that in our own time.
Thank you very much.
I'll just see if we have any questions for you. Jan, any questions for Mr. Randall?
No, Mr. Randall, I have read through all of your notes and I have no questions for you. Thank you.
Thank you.
Ros, any questions?
No questions from me.
And Mr. Randall, no questions from me either, but you'll see from my quick summary back to you in terms of the issues you've raised, we have understood what you've spoken to us about. So
thank you very much.
Thank you for coming in and appearing on behalf of Ms. Burrow.
Thank you for the opportunity, and I am sorry about hassles with the printer and stuff getting here, and I'm sorry to hold you guys up. I'm sorry, hold the proceedings up, but I really appreciate the opportunity to present here, and I thank you for your time. And it was just some other issues which do have effects on wildlife that perhaps haven't been talked about. But you've got my notes, so that's fine.
Yep.
I wasn't going to talk about that. I've just highlighted bits along the way. So I'll leave that with you, and I really appreciate it. I can think, so you've got that copy. Thank you very much for that, sorted out the technical. It does, there's a talk that goes with it about but the notes, the cover notes that go with it are fine. If anyone wants to have a look at those animals, they were the first animal to walk out of the sea. And they've been around for 540 million years, and we're lucky to have them here.
Yep. All right, thank you, Mr. Randall. Enjoy the rest of your day.
Clicker? Thank you very much for your time, everybody.
Right, now at this stage, Kirsten, I think you're free to go, unless there's anything you wish to add to your pre-circulated report. No, thank you for that. Anything by way of procedure from ORC reporting officers at this stage? We've received your end of hearing report.
And I have just emailed the legal submissions
Okay,
as well.
great. So they'll come through in due course, and we'll look at those. And any procedural matters from the applicant at this stage? All right, so we're on track then to reconvene at 2:30 to see if we have questions for you arising from Ms. Lennox, your report, Ms. Milhoff, the legal submissions, and anything we might want to ask your technical advisors. So we're adjourned until 2:30. Thank you very much, everyone.
of us.
Rightio, good afternoon everyone. We now reconvene the hearing, and at this stage we're hearing what's called end of hearing reports from the Council Section 42A reporting officers. Just for the information for anyone who's watching online, we have read and considered the end of hearing report from Kirsten Lindsay, the reporting officer for Dunedin City Council Regulatory. We had no question for Miss Lindsay, so we've released her. So now we have the end of hearing reports, legal and planning from the ORC. And Ms Melhoff, I thought we might wish to commence with the legal submissions, which we've received and read. Thank you. Is there anything you wish to add verbally to that before we proceed to questions?
No, I'm happy just to proceed to questions.
Excellent, thank you. Jan?
Right.
Oh, hang on a minute, I'll just check. Roz, are you online?
Yes, I'm here.
Excellent, good. Sorry, I should have checked earlier. So, right, Jan, thank you.
Okay, my first question relates to something that I didn't find in the legal submissions, but I asked this question of the other lawyers who were here, and I thought I should ask you the same question, and it relates to section 105(1)(c), where there's a discussion, this is of the RMO obviously, where there's a discussion of alternatives, and I just wondered if you wanted to make any comment on that in terms of what you think the provision is driving at, and what you say that means for us in terms of our consideration of alternatives. Could you just address that?
So, in relation to section 105, I think the consideration of alternatives is around the alternative methods of discharge.
Mm-hmm.
So it is specifically relating to the discharge of contaminants. In this instance, the relevant rule in the regional plan does refer to the what's the discharge of waste in the landfill. It's a paraphrase of that rule.
Mm-hmm.
So in this respect, I do think that consideration of alternatives would extend to alternative methods of discharging that waste, given that that's the applicable rule that consent is being
Okay, and in that regard, do you mean at other facilities, for example?
I think it could extend to that consideration, that being within the bounds of, I think it would need to be within the jurisdiction of the regional council, so within the region, not outside of the region.
Right. Okay, thank you. You did mention, I think, along the way, policy 7.4.8 of the regional plan waste,
Mm-hmm.
and that's also featured in the wider section 42A reports. It, to me, didn't appear to exclude the possibility of landfills, but seemed to be starting from the starting point of, we'd like you to look at waste minimisation, and then if you haven't got an alternative method of disposal, a landfill might be your answer. Mm-hmm. Is that how you see that policy?
That is how.
Okay. Did you have any comment on the bond? Because you've heard me asking about this. In terms of the approach that you suggest that we should take to that if we were to grant consent, because you can do what they did at AB Lyme and have a specified sum, but Bridget Irving did mention that there were reasons for why they took that approach there. The more common approach is to have something more like a formulaic approach where you recalculate it according to what your tonnage in the landfill is, and therefore your risk is assessed accordingly. Do you have a comment on that?
Yeah, in my view, I would say that the latter approach is more appropriate, and that I would be supportive of a condition requiring the bond, and I do understand that that may be discussed through the discussion around conditions between the planning experts in terms of how that might be appropriately framed.
Okay. When I read the section near the end of your submissions on the NES, and I appreciate you still had forest and bird on this morning,
Yes.
I didn't sort of get to a conclusive point as to what your answer was on whether it was discretionary or non-complying. So did you have one?
Sorry, I may have removed that as I was amending this morning.
Yeah.
My view is it's discretionary.
Discretionary.
Remains discretionary.
My last question relates to the OSIA conditions, and that section that you've given us on that was really helpful, thanks, because I hadn't revisited some of that law for a wee while. But I just had a question about the Curtin case, because you've quoted one paragraph of it, but I haven't read it yet, so I haven't got my head around what the whole thing was about. Did the court, and sorry, before I go on, over the page you then refer to the Springs Promotions case, but that to me seemed to be talking just about the general OSIA principle that if somebody volunteers this then they can't complain later.
Yes.
Whereas the question I've got for you on Curtin was, despite what that paragraph says, did they say in the court, or in the decision, that the consent conditions, even if they are coming through the OSIA route, should still be clear, robust and enforceable?
I don't recall that specifically from the decision, but in my submission, a condition should always be framed with those requirements in mind, even if it is an OGA condition. If the condition turns out not to be clear and enforceable, if it's an OGA condition, I don't think an applicant could come back and say, we don't need to comply with that condition. But as a starting point, I think any condition should be meeting those requirements.
Yeah. I had a similar view because I was thinking, well, it'd be a bit crazy if you ended up a court sort of saying, well, you can put all these conditions in and then everyone will just have to work with it because it's come in voluntarily. And I thought, well, that can't be right because that's going to lead to all sorts of problems later. Okay. Well, I will read it. I'll read the decision when I get to the long casebook that you sent.
Yes, and the casebook does include every case that's referred to in the submissions, and obviously there's more significant cases than others. So.
Okay. That's all I had. Thank you very much.
Ros, do you have any questions arising from the end of hearing legal submissions?
Yes, I do. I have got a couple of questions for you. With regard to your legal analysis of the weight to be accorded to the partially operative and the proposed RPS, I note that you've listed the relevant principles that apply to when you're determining the relative weight to be placed on these instruments. And at paragraph 23, you've noted circumstances of injustice. And I wondered if there were, what does that kind of clause typically relate to, and do we have any of those matters that we need to be considering in relation to this proposal?
So an example of circumstances of injustice might be that an applicant is caught up in a situation where there is a significant change in a planning document. However, in this instance, I don't think that there are any relevant circumstances of injustice for the panel to consider.
Great, thank you. And you've arrived at the conclusion that some weight should be, so full weight for the partially operative and some weight for the proposed. What does some weight mean? Does that mean kind of consider, take into account?
Yes, in terms of the regional policy statement, the requirement is to have regard to that. I think in terms of some weight, I don't think you can set the RPS to one side and not consider it on the proposed RPS to one side and not consider it on the basis that it is at such an early stage in its process. So I am saying that in terms of your consideration and having regard to that, that you do give it some weight, and I haven't gone any further than saying some weight because in the course of your consideration you do need to look at the particular provisions in the policy statements, how they're framed in terms of wording. Having said that, I would say that there, in my view, there's not a significant difference between, for instance, the policies in the proposed and partially operative regional policy statements in relation to the infrastructure and the effects on infrastructure.
Great, thank you. Thanks very much.
I just got a couple of matters that I'd like to ask you about, and I think it's only fair I put them to you so you can respond as I've done with other participants. I do have a residual concern that we're being asked to shoehorn in conditions that aren't actually related to the consents which have been sought or required from the ORC, particularly in regard to terrestrial ecology within the designated site. And for example, at her paragraph 92, Ms Lennox talks about or invites us to consider imposing conditions relating to habitat clearance and linking them into a discharge and diversion consent, which would be relatively novel in my experience. Of course, that all depends on what conditions the applicant ends up offering on an OGIA basis. And the other issue that I think is yet to be resolved in a final manner is whether or not NES freshwater consents have been applied for, and I've got a few questions for Ms Lennox about that. But just coming back then to OGIA conditions, assuming the applicant still decides to volunteer a bunch of OGIA conditions, do we have to impose an OGIA condition even if it's offered?
Oh, that's a good question. I think if it is offered, it forms part of the application that you're required to consider. And if you, there would need to be good reason to not impose that condition. And yeah, I'm not aware, that's something that I could consider further, but I'm not aware of a particular position in case law around that. That's not to say that there isn't one, but yeah, I don't have that to hand.
Yeah, so is that a yes or a no?
That's a I don't know,
Okay.
I would say. I think with the conditions as they are at the moment, it is a reflection of the moving feast of the application, and that the application has narrowed from when it was first lodged. And as I was working through the comments on the conditions, and Ms Lennox and I both have discussed this in terms of working through and ensuring that condition is still relevant to what is now being sought. That's not to say that if the applicant is proposing that condition and is prepared to, for instance, I'm just using the Falcon management plan as an example, if the applicant is willing to do that, and if that is something that's not relevant to the consents that are now being sought, then in my view it would be appropriate to impose that condition on an OTA basis.
Is that a would be or would not be? I didn't quite hear.
Sorry, it would be appropriate.
Okay. when I've asked that question of other council on similar hearings, they said, no, we're not obliged to. It just depends on whether there's a nexus between what we think the effects of the activities for which consent are and whether we think it would actually serve a resource management purpose. So, but yeah, I appreciate that that might not be very clear. If the applicant did volunteer a bunch of OGIA conditions, would it be useful in terms of the structure of the consent document, should consent be granted, to group those OGIA conditions and to label them as such, so it's clear, would be clear going forward that they were offered on that basis?
Yes, I think you could do that by way of an advice note in the consent conditions that they were offered by the applicant. Having said that, they would be a condition on the resource consent and therefore would need to be enforced. Yeah, that comes to my third question. So I was heartened to hear you say that even OGIA conditions need to be clear, and I'll interpolate certain and enforceable, because we'd be loath to impose a condition that didn't meet those basic criteria. So my third question on OGIA conditions is, should we assume that if the applicant offers an OGIA condition that's not related to the consents actually required from the ORC, given that this is a designated site, and if that condition was supported by Ms Lennox when we come to receive her final comments on conditions, would we assume that the ORC would willingly monitor and enforce such conditions, even if they don't relate to the consents required from the ORC? And I think that aspect would feed into Ms Lennox's consideration of whether that condition should be included on the consent.
Yeah, but I'm assuming that Ms Lennox has said, yes, I still think that's a good condition. So in that case, should we assume the ORC would essentially take responsibility for its enforcement for the duration of the consent?
If it is on a regional council permit, that would be the case.
And finally, just the same question about that Ros asked you about your submission regarding giving some weight to the proposed RPS. My question is, would that extend to assigning provisions in the proposed RPS what I might call determinative weight? So if, for example, all but for a provision in the proposed RPS, the proposal before us was consistent with the statutory instruments, all but for a provision in the proposed RPS, should we assign that determinative weight?
I think looking at the context, in the context of this application, the example of those particular policies might be in relation to freshwater, for instance, because that's where there has been a significant shift. Given that the regional policy statement is giving effect to the NPSFM 2020, I think it wouldn't necessarily be a sole policy in the RPS that's determinative. It would be that in addition to the NPSFM.
I guess what you're saying there, it's in that situation, my question is moot because the higher order instrument requires us to go there anyway. But if it didn't?
If it didn't, I think it would depend on the language in the particular policy. Given if we were looking at the example of the infrastructure policies, I don't think there has been such a significant shift in council policy that would require you to give more weight to the policy in the proposed RPS as the partially operative RPS. So in that instance, I don't think it
Okay.
would be determinative.
Right. Excellent, thank you for that. Appreciate some of the questions we've asked you are tricky questions, that's why we asked them. But no, appreciate your answers to that, thank you very much.
Thank you.
Now, Ms Lennox, and same question to you. Is there anything you wish to add? And thank you very much for your comprehensive reply, and all of the technical people who maybe online have contributed to your report. We appreciate their advice and assistance as well. Is there anything you wish to add at this stage before we go to questions?
Just regarding the question that you asked of Ms Mellop around consideration of alternatives, just a reminder that Ms Mellop did provide a memo attached to the Section 42A report that might assist as well.
All right, Jan, questions?
Now, we're doing questions of Ms Lennox first. Is that how we're doing this, or the technical?
Well, I thought if we just, if you turn the pages on your copy of her end of hearing report, and if the question relates to her, we'll ask it, and if it relates to a technical person, we'll ask it of them. Okay. But we'll let you do your whole suite of questions first, then Roz's questions, then I'll see if there's anything that you guys haven't asked that I still want to ask.
Okay, just give me a minute then, because that wasn't quite what I was going to do, but that's all right. I think the first thing I get to is geotechnical matters, but I'm just trying to find so the first one that comes up is the active landfilling face size. I don't know who on screen, I see Tony Bryce is there. This might be one for you, Mr Bryce. You weren't there a minute ago, I wondered where you were. So the question I had around the size of the face was, you've sort of said that you thought a limit of 1,000 square metres was more reasonable than 300. And the 300 for the applicant had come from its landfill fire risk scenario. So it was one of the experts for the applicant who proposed that, I think, originally. So the question I had to you was, are you aware of any other landfills we have in New Zealand that go as low as 300?
No, I've never seen anything that small. Around about 1,000 is often used and becomes practical. I think 300 square metres would require, moving your tip face every day. It's a difficult way to operate the landfill. It would only just accommodate a day's worth of waste for the volumes expected at Smooth Hill. So it'd be very difficult. But it depends on how the applicant proposes to operate it. If they feel they can operate it that way, it may be possible. I'm just saying it would be extremely difficult.
I mean, I know you're not here as a fire risk expert, so I'm just being careful the way I put this question, but do you have any comment on the 1,000 square metres and whether that would assist in fire risk management?
You're right, I'm not here as a fire risk expert.
You don't need to answer it if it's too far outside of your area, but just thought I'd put it to you while you're there.
No, I'd just like to comment that it's a typical area, and it's obviously managed at other sites.
Okay, let me just carry on down the page because I've got some others for you as well. The next topic is the amount, the putrescible waste and the 10% number. I don't know if you were listening last week, any of you at TNT, about the practicality of sort of taking your putrescible waste out along the waste chain, and Mr Henderson and I had a discussion about that in terms of how that's managed with the waste transfer station and the compaction of waste in the trucks and that sort of thing. Have you got anything that you can share with me about your experience of that?
No, I didn't have that discussion. And look, I've probably got nothing useful to add on that.
Okay. Now, further down the next part of the report, you talk about the leachate collection system. And in your earlier reports, particularly your Section 95 report, which Ms Lennox has highlighted for us, we need to keep those reports in mind as well as the 42A reports, because they all sort of have different content in them and all hang together eventually. You had quite a few concerns about the leachate collection system at that point, and even now you're still saying you, favourite word of some engineers, generally satisfied with the applicant's proposal, being very careful. So is there a bit of the applicant's proposal that you don't like or aren't satisfied about?
Oh no, I think what they're, well, yeah, I'll answer that in two ways. I think what is proposed is quite feasible. It's got redundancy, it's got a separation geotextile above the leachate collection layer, and it's got the ability to clean the leachate. My preference is always to put in more pipes than less, and particularly in areas that leachate could accumulate, such as on the benches. It's not essential, but it's a safeguard that will going to. It gives you an alternative flow path for the leachate. So that would have been my only hesitation. But I believe that the proposal as put forward will work and has sufficient redundancy.
That point about the leachate and the benches was one I think Mr Ife raised for the submitters as well and talked about last week. Have you and Mr Coombe ever had the opportunity to talk about that?
No, we haven't spoken. There was, I mean, he saw my comments and he responded to them in terms of the redundancy. So that, I think that's the extent of the discussion.
Mm. Okay, just give me a minute. The liner specifications, you've helpfully, thank you, given us a consent condition, and this looked to me to be very much like many of the consent conditions I've seen before, with the Type 1 and Type 2 being specified in the consent conditions. When Mr Ife was giving his evidence last week, our chair raised with him whether he thought there might be some merit in any condition, including a reference to permeability, and that being specified in there so that there was an outcome being sought. And I don't know if you heard that discussion, but do you have any comment on that?
We have, I mean, the condition that I put forward there, and the definition of a Type 1 and Type 2 liner has a permeability and a thickness requirement. And so, yes, by all means, that you need to specify the permeability of the clay or the soil liner. That is the most critical part of, of how that should perform.
Okay. One of the comments that sort of intrigued some of the submitters, and wasn't one I'd heard before last week from Mr Coombe, was that the waste becomes inert after about 60 years, and some of his answers were then justified on that basis. Others didn't agree. So have you got any thoughts on that? You've been working in this business a long time.
Yeah, waste becomes more inert over time as it breaks down. I think many years ago we used to talk about 30 years post-closure. I don't think that's realistic. I don't really know what is realistic. I kind of feel that 50 to 60 years from looking at some old landfill sites that I have seen, is probably reasonable, but there's so many variables in terms of what waste has gone and how it's been treated over its life, how well it's covered, how much water's gone through it, and how much degradation occurs. But I don't disagree that with Mr. Cooman that 60 years is possibly a reasonable number to put in there.
Okay. The waste, you've made the comment on the loose, and I don't have any questions around that, I don't think, because you seem to be all right with that. I have a sort of a question that I don't think quite relates to some of the points in this part of the report, but waste acceptance criteria, we've been talking about a number of examples of consent conditions. One of the ones I've referred to is Dome Valley, but we've got conditions that came out of the AB Lime landfill consented last year in Southland. I mean, I'm more familiar with the Hampton Downs and other Enviro waste landfills, and you'll be familiar with all of the waste management landfills, probably. But do you have any comment about the structure of those and how specific they should be, and what is your best experience of that?
Certainly I've been involved in the Dome Valley, and I have not been involved in the waste acceptance side of it. That has been handled by others.
Okay, right.
So I can't comment too much on that. Look, there needs to be some measure of we don't want the landfills to take any form of hazardous waste, and there needs to be some measure of that. Traditionally, there has been reference to the MFE documents, which goes back to I think about 2004, which defines Class A and Class B landfills and refers to the New Zealand waste list. That has been quite commonly used in the past. Whether it's still appropriate is open to question, but yes, look, I can't give you a good example of a good recent example.
Okay. Are you the person I should ask geotechnical questions of, or have we got somebody else on your team there to do that?
No, Andrew Stiles would be far better placed to answer.
Oh, Andrew, he's going to sit up in his chair now.
Thank you, Jody.
Hello. So I'm just going to leap on to geotechnical matters. I was rereading a lot of the material around geotech and groundwater last night, and with the geotechnical information, we've had some comments from some of the submitters, Mr. Rumsby, I think in particular, around the lack of assessment that's been done for seismic risk. Your position seems to be that you were pretty satisfied with where things were sitting on geotech, and the fact that this later study or assessment was going to come in. Is that right? You're at that point?
Yes, that's certainly correct. We raised it during the assessment of the applicant's first studies, and the fact that it is now being proposed to do a full seismic hazard assessment by Professor Sterling. Yep, that's an excellent solution, and we'll come up with a definitive answer.
Just for my own education, but just because I just don't know quite how this works, if you end up getting a study like that in later, and it shows up some unexpected result on seismic conditions, what does that mean for the landfill design? Do you just go back to the start, or how do you deal with that?
I think it would depend upon what comes out of it, but I'm not actually expecting any surprises to come out. Professor Sterling has already raised the PJ up to 0.5 from the 0.31, which they initially assumed. It's pretty clear that he thinks from his studies from University of Otago that Akrotiri Fault is the primary seismic source. So I'm very confident that his study will merely confirm the current design procedures, the current PGA and the current seismic source. If it did throw up something anomalous, which is hard to see what it could be, then the design would obviously have to be reviewed on that basis. And the extent of the review would depend upon the significance and seriousness of what was actually found.
Mm. Okay. So I think what you were saying in the report that's been put before us today is that you consider the risk to be, on the basis of what you've heard from Mr. Sterling, extremely low?
Yes, I would certainly agree with that. I'd already reached that similar conclusion, but he's very much more of a seismic guru, and I think he's reached that conclusion. I would certainly agree with that. I'm very confident that this study will come up with the same answer. If it doesn't, the design would have to be modified to suit.
Okay. All right. And now, who does groundwater? Is that Ms. Lockheed? Are you coming in on that one?
Yes, it is, yeah.
Hello. Sorry to be pulling you in and out like this. It's just the way that we've got to get through this report. Thank you for all of your comments as well. Your 42A comments, well, through Ms. Lennox's report, raised a number of uncertainties and problems with the locations of the groundwater bores. And I know that a lot of this has been ironed out in the discussions that you've had with the applicant since then, so I'm going right back to your original reports and all the discussions that have occurred. Are you now confident that the groundwater effects are well established and can be relied upon?
Yes, yeah, we had a good discussion prior to this, and the monitoring boreholes have been sort of amended to capture the upstream and downstream gradients.
Okay, and that's just as a result of your process you've gone through with your various reports and your Section 92 requests and your discussions?
That's right, yes. There was one comment about at the middle of a site, there wasn't a monitoring well in the shallow groundwater system at borehole 301. That was the only comment which was really left outstanding.
Okay. We've now sort of got to the point where there's going to be quite a bit of monitoring going on for 36 months. And I take it you're just anticipating that's going to confirm to you the baseline conditions of the site, and everything will then sort of proceed from there. Anything that you wish to comment on in regard to that monitoring program and how that might eventually pan out with the design? Are you expecting it to throw up anything unusual?
The applicant has undertaken 5 monitoring rounds, and looking at that data so far, the groundwater quality seems fairly stable, just almost 5 monitoring rounds. So we'd expect after 36 months of monitoring, that would be able to give us the results of to perform a baseline monitoring really. So the answer to that is that it can be confirmed after 36 months.
Yeah. So you're quite confident that you're getting a fairly stable and consistent picture. That's really what you're telling me, I think.
That's right. Yeah.
Right. Okay. I've got no other questions for you. Thank you very much.
Okay, thank you.
That's all your questions? Okay,
So,
Ros, questions, you happy to proceed on the same basis, just turning the page on Ms. Lennox's report and asking the appropriate author to answer your question?
Yes, that's fine with me. So I do have a few questions for Mr. Markham regarding the terrestrial ecology.
Hello.
Hi. I'll start with in Ms. Lennox's report, there's from paragraph 39, where you're responding to Dr. Morris's evidence, and you've gone through numerous aspects of the evidence he presented to us, and I see that there is still some areas of dispute. And so what I was wondering is whether you could highlight to me those areas of dispute that aren't yet resolved by way of a proposed condition, because it seemed to me that you were pointing out some areas of dispute, but that in the same breath, perhaps conditions could manage it. So is there anything in particular that you still have concerns on with regard to, material effects?
I guess to answer that concisely is the only, area of dispute still is the impact or effect on the wetlands, and what that could be, and whether or not it would be required to be offset or compensated for, depending on where it falls in the effects management hierarchy. I don't necessarily think it's a dispute. I think if I picked up in Dr. Morris's evidence that he has agreed, although he thinks that there will be no effect, he's sort of agreed that monitoring is required, and picking up information from other technical experts in terms of how much change in the groundwater and how much change in the surface water, and agreed that a condition could be applied. We haven't agreed on a condition yet, and just picking up on the point there that the condition for that monitoring will need to be quite prescribed with standards and triggers in it, so it is enforceable.
Sure, I see. So I guess you'll be wanting to reserve your final judgment until such time you get a response from the applicant on what that condition might look like. Is that what you're saying?
Correct. Okay,
thank you. So moving on now to paragraph 40 in relation to the Eastern Falcon. So you've noted that you agree with the intention of the witness's expert around amending condition 66, but you've noted that the wording is a bit ambiguous. Do you have any suggestions? Do you think that's going to be easily resolved in the sense of clarifying that, or do you think it's fundamentally off track?
No, I think it's easily resolved in terms of reviewing a draft condition and then potentially just tweaking a few words or putting triggers or actions into that condition so it's fulsome.
Right, so again, that would be something that the applicant could attend to in their right of reply?
If they wish, yes.
Okay, thank you. And that was my last question for you. Thank you, Mr. Markham.
Thank you.
I had a question for Mr. Chilton. Mr. Chilton's here?
Yes, hello, sorry, finding the right buttons.
Hi, so Mr. Chilton, during submissions from the legal counsel for one of the submitter groups, Ms. Irvin, in relation to air discharges, she noted at paragraph 31 of her written submissions that it's now common for hydrogen sulfide monitors to be utilised to help and monitor with odour emissions, and I wondered if you had any comment on that. I didn't see any comment in the response that's included in Ms. Lennox's summary.
That's more common in terms of just taking measurements in terms of the landfill gas from the leachate wells and the gas extraction and possibly using it for surface walkovers just to check the integrity of the cap, if you like. It's not usually something that from an off-site odour effects point of view, it's not really done to manage off-site odour effects. It's more about just maintenance and management of the cap integrity.
I see.
And
Thank
the
you.
gas extraction system.
Okay, I see that now. Thank you.
Yep.
And I had a couple of questions for Ms. Lennox. So at paragraph 78, I'll just get to that myself. You've noted in the second sentence, that the risk of bird strike has not been adequately assessed, and as a result the applicant's wider bird management strategy is not sufficiently developed. So I was just wanting to understand the basis on which you've arrived at that view. Is that in terms of some of the evidence we've heard from submitters, particularly the airport, that there's no longitudinal studies being presented to us?
So that came from a better understanding that I've gained over the last 2 weeks around what is actually being proposed in terms of bird management. And I had already identified previously that the bird risk assessment undertaken to date was a preliminary study, and that was discussed several times over the last 2 weeks. And when I was going through in part A of this report, when I've looked at part C of this report, when I've looked at all of the different components of the wider bird management strategy that Mr. Shaw has talked about. So it's not just about the mitigation measures actually at the landfill itself, but there's been lots of discussion about what needs to be done at Green Island and what needs to be done at these colonies as well. And so I really don't have any understanding, and I don't think the work has been done to identify what would need to be done at Green Island and what would or could even be done at all of these colonies too. So that's where my that statement has come from when I've talked about that the wider bird management strategy is not sufficiently developed. So for example, in part C of that report, I've talked about how I don't believe that we can impose a consent condition at this point to say what must be done at Green Island, because we still don't know what needs to be done at Green Island.
So, yeah, thank you, that's really helpful. Thanks for setting that out for me. And further down at paragraph 81, you've mentioned in the first sentence there, the applicant's conclusions are supported by a limited program of investigations resulting in a lack of certainty. So I was interested there again, if you could just talk me through that. Over the last couple of weeks, we've been presented with numerous management plans and monitoring proposals. So I'm just interested in you teasing out that statement for me a little further.
Yep, so just to reiterate what I just said about the bird management component, but throughout this application we have identified areas where the information just isn't there yet. And, you know, we've already just talked about a couple of minutes ago about how the fact that the seismic risk assessment hasn't been done yet. You know, is it going to yield any different outcome? We probably not, but we're just not sure. And normally you would expect that sort of thing to be done before the application was lodged. A lot of the surface water, groundwater monitoring, both in terms of quality and existing environment quantity and hydrology and hydrogeology, a lot of that work would have been done before the application was lodged. Even some of the terrestrial matters, and I'm sure we're going to talk soon about whether or not they're applicable, but the lizards, for example, there's a lot of work that just hasn't been done yet. And we've got conditions requiring that the work is done, and then plans are written based on the results of those further studies. But if you would, I believe that the way that policy is to be interpreted is that, you know, if you're not quite sure yet, then you need to proceed with caution. And that was the basis of those statements.
Certainly, thank you. Thanks for walking me through that. And in regard to the applicability of the terrestrial matters, I'll leave that for our chair, because I know that he will be wanting to pursue those questions for you. But yes, that's all of my questions. Thank you.
Thank you. So, Ms. Melville, I forgot to ask you a question, and Jan's got some other questions as well. So,
sorry,
Jan, do you want to go first?
I forgot to ask Ms. Lennox a question. Sorry about that. I just wanted to ask you about the bond, because I asked your counsel about it too, but do you have any comments that you'd like to make about how you would see any bond coming forward? Do you agree that it will be the more formulaic approach? if we were going to grant consent?
So my only experience of putting bonds on to in a consent condition was for a large mining activity, and the purpose of and that was a privately owned entity, and so the idea of having the bond there was in the event that basically the owner walks away from it, and then someone's left with cleaning up the site. And I think that's less likely in this situation because it is a publicly owned facility essentially. But I did see, and I could find it, I can't pull it up right now, but I did see some consent conditions that went onto a recent landfill, and it talked about bonds to help essentially in the event of adverse effects on the environment that weren't anticipated at the time the consent was granted, and just helping to make sure that those effects are remediated. So I don't have a lot of experience with bonds, to be honest with you.
Okay. No, because I mean, one of the issues I was raising with the applicant was the possibility that it may not always be a publicly owned facility, and that somebody one day might privately own it, in which case the whole abandonment argument comes forward. And I've been involved in discussions at Hampton Downs about similar points, because that is private and is now owned by a Chinese company. So it's sort of, a lot of the calculations that are done are a bit like the binding one, and actually done on the basis that there's a problem, somebody walks away, and somebody else has to fix whatever the problem is. So, but you've got nothing that you can really assist me with by the sound of that. I mean, I know the mining approaches because they're very similar, but...
I did read one sometime over the last 2 weeks, but I've read a lot,
Yeah,
so I can try and find it for you.
No,
But
it's
I
okay.
can't
I'm
pull it up
quite
right now.
Yeah. I just that's all I needed to know. Thank you. Sorry, I didn't ask that before.
Thank you. So, Ms. Melhoft, I forgot to ask you, your overall conclusion regarding consent category you said was discretionary, and that is, my question here is on the presumption that NES freshwater consents have been applied for, and I think your final advice to us was that in your view, even under bundling approach, the overall category remains discretionary. Is that because of the application of Section 88A? So you don't agree with the legal submissions from Forest and Bird?
No.
Okay. Okay. Now I only have questions for Ms. Lennox, Mr. Cochrane, just one question, and then a bunch of questions for Mr. Markham. So anyone else who's currently watching, unless you're super interested, you don't have to watch anymore, but of course you're welcome to. That's in terms of the technical advisors. And Ms. Melhoft, in terms of my first bunch of questions and my last bunch of questions to Ms. Lennox, if you think you can assist us with any kind of legal view, I'm happy for you to come in as well.
Great.
So first of all, just returning to this issue that you can see as a bugbear of mine, in terms of the NES fresh water, under Section 88A, applications for consents need to be in this prescribed, Section 88, sorry, they need to be in the prescribed form. Does the ORC have application forms for NES freshwater consents?
I can't answer that, sorry.
Don't know. Would you be able to find out?
Yeah, certainly.
So my next question was going to be, and you may not know the answer to that, I was interested to know if the ORC did have copies of NES freshwater application forms, given the requirements in Section 88 for the prescribed form to be followed. I was going to ask for a copy of their application forms that they would have filled in. So if there are forms and if they have been filled in, I'd like to see a copy, and if there are no forms, then of course that line of questioning is moot. Did you or anyone else in the ORC undertake a Section 88 completeness assessment of NES freshwater applications?
No.
And I do note in your Section 95 report, though, you did consider the NES freshwater, or you assumed NES freshwater applications had been made and you assessed them in your Section 95 report, didn't you?
Yes.
Yes.
Yes, it's not been uncommon to receive an application, undertake the Section 88. The original application would have had the forms, and then for whatever reason, at some point you've identified that additional consents have been required. ORC's practice would not usually be to require someone to fill in an extra form or to you would identify if further information was needed to even, set up Schedule 4. However, this one is slightly different in that the consents are actually required under a different statutory document.
Yeah.
So, should we have been more thorough? We were proceeding on the basis of what is usually acceptable.
Sure. So, Mr. Cochrane, paragraph 29.2, just let me rewind that. Good afternoon. I'm just interested in potentially adverse effects on the swamp wetland at the toe of the proposed landfill, particularly with regard to some of the evidence we've had from experts for submitters saying their concern relates to the invasion of exotic weeds and other plants into that wetlands should the water level drop, or should it be dewatered to some extent as a result of the proposed landfill activities, diverting surface water and groundwater, etc. Have you given any consideration to a trigger point which would enable us to say, should the water level in the existing swamp wetland drop by X amount or to X level, then remediation or offsetting activities should be undertaken? Sorry, can't hear you. Still can't hear you.
How about that?
Yeah, good, loud and clear, thank you.
My apologies, no, I haven't, Mr. Chairman. And the reason that I haven't is that I've been unable to quantify what the change in water level might actually be as a result of the landfill.
Yeah, putting that to one side though, are you able, or have you thought about, in terms of your expertise, if the water level was to drop by X amount, then offsetting or remediation work should occur?
The threshold for offsetting or mitigation is probably best addressed by Josh Markham. I could certainly quantify on the potential extent of dewatering or changing of water levels in the wetland. But the effect of that in terms of some of the issues that you've raised around weed infestation, probably more a question that Mr. Markham would be able to answer.
Sure, okay, no, that's good, because of course any kind of water level drop trigger level would only be useful if it was then going to require some kind of ecological remediation or offsetting probably. All right, so Mr. Cochrane, thanks for that. Mr. Markham, so the rest of my questions in terms of the technical advisors are for you. Just while you're there, do you want to answer that one first?
Yeah, no, that's fine. My response would be to set the trigger or level or standard based from the baseline itself as current baseline in terms of the wetland extent based on vegetation and hydric soils. I guess picking up in the evidence, we've sort of discussed and there's a disagreement between Dr. Morris and myself about how much change is required before offsetting, and I would say any change from the baseline condition. So clearly establishing that baseline is very important.
When you say the words baseline condition, what do you mean by that?
Baseline condition in terms of the wetland extent as it currently is, based on the surrounding land use. And that wetland extent is based on hydric soils, it's based on physical habitat characteristics and plant communities. And I think that sort of also would answer some of the submitters' concerns that came out of Dr. Calvin Lloyd as well. Otherwise, it seems quite arbitrary to put on a 5% change or a 10% change or a 20% change is allowed, because there's no basis for that percentage.
So when you say wetland extent, do you refer to the area of the wetland? Is that what you mean?
Yes, yeah, the area of wetland, but based on hydric soil characteristics and based on plant communities.
Yeah.
So virtually those are the metrics that you're measuring. And I would suggest that a condition, if a condition is put forward, it should have those enforceable standards in it that makes up the baseline condition.
Yep. Okay. Now, I've got a number of questions for you, and don't be upset by the conditions. They relate to I'm interested in scope that we have to impose conditions should the applicant resile from some of what are probably OGIA conditions at this stage. So I just want to ask you some questions about your material here. So my first one was at your paragraph, or the paragraph 40.1. Have you got that?
Oh, sorry.
So just let me know when you've got that up.
Yep, I have that up now.
Good. So when you say there in the second line, mortality of nesting falcons, what causes of mortality were you thinking of then?
What causes the mortality, is that the question?
What causes of mortality did you have in mind when you wrote that?
Vegetation felling during nesting season.
So sorry, didn't hear that.
Vegetation removal during nesting season.
Okay. That's good. And I've asked this question of some of the other witnesses. To your knowledge, do the falcons nest in the swamp wetland that's at the toe of the proposed landfill site?
No. Currently in that swamp wetland, there's no vegetation of stature for the falcon to nest in.
Yep.
The falcon predominantly nest in old growth forest or large pine trees or large old macacarpa trees.
Okay.
That give them quite a high nesting roost.
Okay. That's probably answered my next question, but I'll just ask it anyway, just to get it on the record. To your knowledge, do falcons nest in the vegetation in the roadside margins along McLaren Gully Road? So in the rank grass margins adjacent to McLaren Gully Road, would falcons nest in there?
No.
No. And just bear with me, I can't write very fast. Next question, 41.1. You say there in the second line, if more lizards are found, when you wrote the words are found, what area were you referring to? Found where?
Referring to rank grass along the road verge.
Good.
Grass can be found in very high densities in rank grass.
Yep. Okay, that's good. 42.3, and you say there in the very last, or there's only 3 lines there, but in 42.3, the third line, desired ecological outcome. What did you have in mind when you wrote those words?
Oh, sorry, I'm going to bring that up again. $43.1.
42.3, sorry, I might have said the wrong number.
42.3.
Yep.
the desired ecological outcomes is in order to balance or account for the residual effect. So I'm not saying that the desired outcomes of what I believe the outcomes are. I'm saying that the desired outcomes would reach a no net loss in biodiversity value and potentially net gain based on the modelling approach.
Yep, and you used the words there in your first part to that answer, residual effects. Do you want a residual effect? Do you want to tell us what you meant by that?
What I meant by that is an effect after mitigation is applied. The residual effect that you left over that requires some amount of either offsetting or compensation.
Yeah, sorry, no, I understand that in general terms. Can you be more specific in terms of sort of ecological things? What kind of ecological residual effects did you have in mind when you wrote that?
Loss of wetland area.
Yep.
Or value or characteristic.
Yep, so loss of wetland area or the nature of that wetland, its characteristics.
Yep.
Anything else?
Potentially lizards as well, impact on lizards depending on what the residual effect is after mitigation is applied.
Yep. And anything else?
No, that's it.
No, that's good, thank you. And just while we're on that page, in your paragraph 42.1, you cross-refer to condition 68, which is the conditions that Mr. Dale had attached to his evidence. Now, you probably don't need to turn to those, and it might be hard for you to do so, but that condition 68 refers to drawing 1250638-1-C309, which I couldn't find in my documentation just over lunch. But why I'm asking that question is that condition refers to cross-sections of wetland areas, WT1, WT2 to 4, 5 and 6. Off the top of your head, can you tell me which wetland those cross-sections are in? Because I couldn't find that plan.
No, I can't. I was merely referring to those set of conditions working together to have an outcome.
Yep. Okay, well, just while I remember that then, so Ms. Kindiak, could you provide me with a copy of that particular plan? 1250638-1-C309. I could find C308 and 3010, but I couldn't find 309. Probably not looking in the right place, but okay. So, Mr. Markham, just come back to you. So I'm just now looking at your 44.3. And I just want to ask you there, for the 4 things that you list there, lizards, avifauna, wetlands and vegetation, for each of those 4 things, can you tell me which area you had in mind regarding those 4 things? So for instance, on lizards, you've already referred to the roadside margins of rank grass. Is that what you had in mind there, or were you referring to a wider area as well, for example?
Just the rank grass for the lizards and the road verge, the wetland area for vegetation and wetland extent itself and the vegetation communities, and avifauna is probably the one that is referring to the removal of current pine trees within the designation.
Yeah. And the wetlands, was that the swamp wetland at the toe of the landfill, or does it include wetlands further down the catchment?
Both.
Okay.
Because depending on what the hydrological change or effect is, it could have the potential to change the dynamics in both of them.
Yep. Okay, that's helpful, thank you. Oh, and did we cover off vegetation? I can't remember.
yes, for in terms of vegetation within the wetlands and the immediate surrounds.
Yep. So wetlands and their margins, would that, if I wrote that down, would that be fair?
Yep.
Yep.
That would be correct.
Good. No, I think that's all I had for you. Thanks very much.
Okay, thank you.
So Ms. Lennox, just coming back to you now with a couple more questions. So I'm now looking at your paragraph 92, and I'm looking at the last sentence. Yeah, 92, sorry. Yeah, Ms. Lennox, sorry, I speak louder. Paragraph 92. So the very last sentence you say there, effects on terrestrial ecology will still be a matter for consideration for the NES land use consents. When you say terrestrial ecology, what were you referring to there?
The avifauna, lizards and flora within the area that's going to be impacted by earthworks requiring consent under the NES.
So that would be within 10 metres of the swamp wetland?
And 100 metres if you accept my discussion around consents being required under that regulation as well.
Yeah. So Ms. Melhoff, happy for you to jump in here. I would have thought in terms of the intent of the NES freshwater regulations and the consents required under them, which are focused entirely on natural wetlands, that the consideration of terrestrial ecology would necessarily be directed to the natural wetland, not to any dry land terrestrial habitat or ecology away from the wetland. Is that an unreasonable assumption or a reasonable assumption?
Yeah, I would say that's a reasonable assumption. It would be in relation to the effects on the natural wetland as a result of the earthworks.
Can I just add to that?
Absolutely, yep.
I appreciate that there has been considerable time assessing effects of activities that you might not see under a discharge permit. And I think that a lot of these terrestrial effects are essentially a little bit of a hangover from when the original application came in, and it did involve impact over a much larger area.
Yeah.
And so,
Sure.
you know, as the application has been, the size of the landfill itself has been reduced, we haven't necessarily reduced the scope of effects.
Because initially it was going to go all over that wetland, wasn't it? So I totally understand that, but things have moved back, so hence the nature of that question. All right. Now, I just got a series of questions arising from your paragraph 100, which is a key paragraph in terms of your overall recommendation to us. And again, Ms. Melhoff, very happy for you to jump in if you think you can assist. So the first bullet point, actual and potential effects on the risk of bird strike, obviously a key matter for us to consider, and we've had a lot of evidence on that. So I just want to confirm, when you say effects from the proposal on, and I'm assuming what you mean there is on the risk of bird strike, are considered to be significant, that in coming to that conclusion you've taken into account the mitigation package offered by the applicant?
I have taken that into account, but in Part C of this report, I concluded that a lot of what has been discussed as being part of the mitigation package I don't see as being actions that you could put on as a consent condition.
Yeah, exactly, like in terms of the breeding colonies, etc.
Even the activities on the site itself, I found it hard to see how it was going to be essentially enacted.
Right. Yep. Okay, but I guess I just wanted to check that yes, you have considered that mitigation package. You have some reservations about aspects of it, but that was very much part of your thinking.
Yes, definitely. And it was tricky writing this report because there is still a lot that is unknown in terms of what the applicant's going to offer, but I didn't want to write a report that was just said, I don't know yet.
Sure.
So
Yep.
this was a key matter that I did want to spend some time on.
No, that's all good and we appreciate that. It's helpful. I'm just turning now to your third bullet point and the words disposal at an alternative location. Now, Ms Melhoff has advised us from a legal perspective that needs to be confined to locations within the region. So, bearing that in mind, which alternative locations, based on the evidence we've received, do you think are viable locations, viable alternative locations?
Based on the evidence that's been submitted, I'm not convinced that there was another Class 1 facility identified in the region. I know they exist, but I don't think anyone's discussed them.
So I'm just a little bit confused now. So is that still a matter that's leading you to recommend declining, that disposal at an alternative location is more appropriate?
So I think that I'm trying to be mindful of only talking about matters that have been, or suggestions that have been actually presented in the application or discussed over the last 2 weeks.
Yep.
And so there was an unanswered question which I raised in the Section 42A report, which was where the applicant when they provided me with further detail about the business case that was explored in 2018, they talked about disposal outside of the district, and they also looked at, but they didn't say is it outside of the region. So I didn't know if those sites that they had looked at were outside of the region or not. And they also said they had looked at private facilities, but they hadn't identified whether they were viable or not. So there were a couple of, I didn't have a full understanding about what all the options were. I didn't think, though, that necessarily that we've only heard about the viable options.
So in terms of assessing alternatives, the case law is quite clear that it's not our role to undertake our own assessment of alternatives. We don't have to be satisfied that the applicant has chosen the best alternative. We merely need to be satisfied that they've undertaken a reasonable assessment of alternatives. Do you think they've undertaken a reasonable assessment of alternatives?
The information that they provided to me indicated that they have explored other sites outside of the district and possibly in the region, and also that they have explored private facilities in the district, but I haven't been provided with that detail, so I can't provide an opinion on whether that assessment was adequate.
Not adequate.
Oh, sorry.
The words are very important. And the word is reasonable.
I can't say because I don't have the detail of that assessment.
Okay. And then the next part of that bullet point that I didn't quite understand, just moving on in that second line, and these are important questions because they relate, as I understand it, to your recommendation to decline consent, so it's quite important we drill into them. You say, and additional treatment prior to discharge. What do you mean by that?
Further removal of the putrescible waste from the waste stream.
Okay. So the discharge is the discharge of waste to land, and the further treatment is further removing putrescible material
from that waste stream before
okay.
it's discharged.
That's good. And in terms of that, then that's helpful answer, thanks for that. does that putrescible, oh, was there trouble saying that word, relate to contamination of the general waste stream, or does it relate to what I think the applicant's calling highly odorous wastes?
In terms of managing the risk of the activity, when I wrote the Section 42A report, I don't think I had a clear understanding in my mind about the food waste, green waste versus these highly odorous wastes. It wasn't until we heard submissions from others that the potential attractor of some of these highly odorous wastes really became apparent to me. Having heard all of that information, it seems that to manage the risk of bird strike, you possibly would look to further treat the waste stream by not having those highly odorous wastes in there too.
Okay. No, that's very helpful, thank you. That's the end of my questions. I'll just see if any of my colleagues have any follow-up questions for either of you. Jan, any other matters you wish to ask them while they're here?
Well, just something that's sort of playing on my mind from that interchange you've both just had, and that's relating to the 105 matter again. I'm just trying to find the... I'll just stay with your last few paragraphs, but we were talking about disposal at an alternative location and additional treatment prior to discharge, etc. You mentioned that you didn't feel like you had sufficient evidence, I think, on a Class 1 landfill alternative. Do you think you have evidence of other disposal types, if you like? So places where you could take recycling, places where you could take batteries, etc. Because that's a slightly different topic. And does it fit within 105 anyway? So there's two parts to my question.
So are you asking if we've had enough, if that information's been presented?
Well, yes, and so maybe I should ask the second question first. Do you think that that provision enables us to look at what you might call waste minimisation initiatives, so that some of the waste is going somewhere else? And if so it's not just a Class 1 landfill. And if the answer is yes, do you think you've seen enough evidence on that?
If that process, waste reduction or removing those particularly hazardous wastes from the waste stream fits into the category of further treatment of the waste stream, then I think that is something that would come under 105 1C, under further treatment.
Yeah.
I just don't know if this is the right time to add this, but I've just heard that in response to a much earlier question, that the ORC does have forms for NES activities, and most of them were available as of February 2021, but there were a number that were published after that. So there were some forms at the time that the application was amended.
Oh, great. So if any of those were filled in, nice to see a copy of those.
They weren't.
Oh, okay.
If I can add to that as well, I've just been having a look in the meantime, and those forms are available on the Regional Council's website in relation to various parts of the NES. In terms of Section 88 and its reference to the prescribed form, that prescribed form is the form prescribed in the regulations, and the form prescribed in the regulations is a generic form, but it's a form that applies to any application for a resource consent. So the Regional Council has a standard Form 1 that must be filled out for any application, and then there's a series of additional forms that I understand the Council's prepared to make it easier for consent
Sure.
applicants to then use those forms to make an application.
Okay. I mean, I don't even know how important this is, but so just to summarise that then, so ORC had some forms available, but in this case they weren't filled in.
It's the understanding that those additional forms may not have been filled in, but the applicant can probably confirm that as well in terms of...
Oh yeah, I'm sure they could, but I would have thought the council would also know whether or not forms had been submitted.
Yeah.
I mean, all of that just cuts to, you know, whether or not applications have been lodged or not.
Yeah.
And a fully filled in form would have been perfect proof of that.
Yes, and as I said, there's I guess a minimum form that's required to meet the requirements of Section 88 for being a prescribed form, and then there are other forms that are for ease of application and use.
Yep, sure. Sorry, Jan, I think you were asking some questions.
No, I'm fine, thank you. No, I think we'd reached the end of our discussion, hadn't we?
Okay.
Yeah, so, thank you.
Ros, any follow-up questions or matters arising for you?
Yes, I just have one further question from Ms Lennox, and it relates to the matter of hours of operation. So during the course of the hearing proceedings, we've heard from a number of submitters, and there seems to be a consistent concern around the impact of operations particularly during the weekend hours. And I wondered if you had anything to add there, or whether you had had a chance to consider any factors relevant to us in that regard.
So I understand that a lot of the concerns around the hours of operation are relating to noise.
Mm-hmm.
And we did look at noise earlier on, and we identified that the applicant would be able, or should be able, to meet the noise limits in the on the designation. I don't know. I would have to look at the designation again to see if there were any times around when that noise was allowed to be emitted from the site under the designation.
Sure. Yep, that's fine.
Thanks, Ros. That's just reminded me of something. So just to the applicant's reps. So I think the latest proposal from the applicant is to operate from 8 a.m. to 6 p.m. 7 days a week. I think there was in Mr Henderson's evidence in response to concerns from one of the forestry company submitters from memory. When you do the reply in due course, would you be able to consider the matter raised by a number of submitters about the feasibility and willingness of the applicant, feasibility first in terms of the proposed operation of the landfill, and then willingness of the applicant to consider not operating on a Saturday afternoon and or not operating on a Sunday? Just if you could just cover that off in reply. I'm not trying to presuppose what you might come up with, but if you could just address that, that would be helpful. And just while we're on that, Jan or Ros, are there any other matters that you would wish to direct the applicant to address in their eventual reply report? I think this is a good opportunity if there's anything floating around in your mind that you'd like them to address specifically. Jan, is there anything off the top of your head you'd like them to turn their mind to that we haven't already covered during the hearing?
No, I don't think so. I mean, I'll probably have to sort of go back through a few notes to make sure I don't leave any loose ends, but I was hoping I hadn't done that along the way. No, I mean, I think all I can say is just please be mindful that a number of concerns have been raised with the applicant along the way, and we're looking for a comprehensive response from you on those.
Okay.
Thank you.
Sorry. And Ros, anything you'd like the applicant to cover off in their reply? Anything in particular that we haven't already addressed?
Nothing in particular that we haven't already addressed today. Nothing further to add.
All right, well, thanks very much for that. So that brings us to the conclusion of this part of the hearing. So to the ORC 4218, thank you very much for the work you've done in answering our questions, even though some of them you probably didn't like being asked too much. And to the applicant, thanks for the assistance you provided to date, and we look forward to the further work that's going to be undertaken. And just reinforcing that in terms of the reply, we're anticipating a revised suite of recommended conditions for both the DCC land use consent and the ORC suite of consents, based on what we hope will be cooperation and consideration by Ms Lennox and her team and the applicant's team, with areas of agreement and disagreement clearly outlined. That would be the most helpful form for us to receive it. Yep, and I'm sure we discussed that previously. I just wanted to just emphasise that. All right, so that brings us to the end of this part of the hearing. We're obviously just adjourned. I will be issuing a procedural minute just setting out the process that we'd like to see followed from here, but it's a process we have discussed previously regarding the further bit of work on the public health assessment, and then opportunity for comment, and then a final reply thereafter. So that's great. Thanks very much, everyone. Enjoy the rest of your day.
Thank you.